Second on the each Gupta. We will be assessed surgery to get on the personal. Number 37. Second consent. In item number 40 also, we could not take consent. We don't get that out. They are asking for time for whom? On behalf of H Gupta CDC and the community. We make surgery. Then we in game of I don't have any idea you suddenly you will. Okay, which he will matter. Item number 40, I have not. No, so all these matters would see when the matter is we take into account that he's not well. No, no. How like that? I know. This kind of I have to implement health safety with the party. Item number 25. Here in my pilot, health safety to be implemented as a party member. So I request 2 weeks time. The DKJ instructs that the petitioner has to sign improvement application. Taking into account the above matter to be listed only upon application for the treatment by.
I wait for adjournment of item number 10 of today's case. Since the petitioner is in a serious health condition, is under dialysis actually. Last time I attempted to open instance whether the order has been complied with or not, but still now I could not obtain. So may 4 weeks time be given. It's under medical care. I
Item number 10.
yes, you know.
Let us see why the matter is up now.
Page of workshop, I have to mention item number 35 from adjournment.
The
Council of the petition.
No, I have been told that money he's seeking adjournment only for me. They will do some rituals are required to be performed today. He has no objection to fix it on 14. So the matter was the convenience of these persons concerned. Every time he's been asking time, that day also time was from. At the request of the Standing Council of the APTCL, the matter stands adjourned to be listed after 4 weeks. You know, anything. No. It's very modern. No, there is no. Let it be some date, maybe 1 week. I'm helping. There's no interim order. So there's nothing on it. Okay. Yes, what happened?
Yes, so this is the same matter whether we can come against a lockout. The lockout was supposed to be legal by the tribunal. Then they come file the recognition, we are challenging the lockout. The settings, it's not until the settlement was reached with the document. And the main crux of the settlement was that we have to pay the amount in 2 installments, one by 12th of January and another by 13th of April. And third was that in vacated notice by 21st of May. And the compliance certificate was filed. It's not complied, the amount of violations of this opportunity. So accordingly, we have given this to all the workers as general notice as well as special notice. They had collected the first installment. Second installment also, all had collected initially, 27 had collected, 14 were not collected. Then we gave a notice stating that if you don't collect, you have to give it before this honorable court. So they ultimately collected. Now what has happened about it? In the meantime, before collecting the second installment, a notice has been received from the Assistant Deputy Commissioner seeking status of the implementation of this honorable court. Though it was the specific jurisdiction of this honorable court to seek the implementation, if at all, violation or implementation. the purview of this honor. However, we replied to the letter stating that we have paid the first installment, second installment paid in due course, and thirdly, we also mentioned that compliance is within the purview of this honorable court.
What is this notice?
Yes, now your option, yeah, it is by this notice now. Even after taking that document at page 246. They have collected, all the workers have collected.
So on 29th April, did you visit there?
No, we have given a reply. If your lordship sees that they have filed the petition now, the union, what the though they say that just and proper implementation of the order, if your lordship turns to page 249. It's the body of it. Their prayer is for just and proper. But what they are seeking is if your lordship sees paragraph 6, 249. May I read the code? That 23 and the management is submitted a list of workers showing payment amounting to so and so before the mediator. The management has not disclosed the intention to the union whether the said admitted entitled amount is. Now they are trying to create an issue of whether the amount that was exchanged during the mediation process, we will pay them after accepting both the installment. And like, and the assistant level commissioner now has got to see the entertainment. Now, if we attend this meeting or not, in case this amount to consultation process, if it fails, they will again now create a dispute. They will create a reference case and they will continue staying in the quarters. This
What happened on 29th?
29th, your lordship, we have given a reply that no, we are not attending, stating that this honorable court has jurisdiction, compliance of the file, and there is the ACL has ALC has no jurisdiction to see the implementation of the order. Because now they are trying to create an issue. That letter we have annexed at page 50. Annex all the checks and the receipt vouchers of the first installment and the second installment of all the 14.
This matter again on 12th of June. See, after 8 6 whether plans have to be taken.
Otherwise, annex all the
Not necessary. You file your compliance affidavit.
no, we have not raised
Then
with file it.
you have not done what is required. We'll see what happens later on. You have to say that we have filed a compliance affidavit and matter is over there.
Yes, but they have to vacate by 31st May and the complaint is up.
31st May has not come in.
Yes, yes.
So why you are coming before this?
This will be a-
There are two ways, Mr. Sharma. Either I dismiss it as premature or I put it down here. Which one? Either.
so this notice
No notice.
after
No notice. It is why I say list the matter on 12. Notice is getting a notice is very good. Not very so easy.
obliged.
What are you?
I was appointed in 1988. Then I superannuated in 2019. After my retirement, gratuity wasn't paid to me. So I approached this honorable court. This honorable court had an anxious seat directed the AGX which is a performer respondent manner, to release my gratitude. Now, the gratitude which was released by is at page 39. Page 39 is where the gratitude was released to the pursuant to the orders of the Supreme Court.
Yes.
Page 39, my lord, you could also see the amount of gratuity which was disbursed to me, my lord, amounted to around 7 lakhs. Now, aspect of gratuity, computation of gratuity is laid down in section 3 of the Payment of Gratuity Act, which is based on the definition of wages. Now, pursuant to that, my lord, gratuity which is monetary comes to around somewhere around 10 lakhs. So there was a dispute with that. Yeah. So pursuant to that, he approached the Assistant Legal Commissioner, which will also be find as Form N at page 27 onwards. Form N. Annexure E. Form N. Then pursuant to that, my lord, there was a reply from the AGMC, which is at page 54.
And after that, there's some order passed by this court on 2/4.
No, my lord, those orders were appended in the application. Those orders were part of annexure A, B, and C as well. So we had appended the entire set of circumstances for the ALC. Form N starts at page 27. My appointment order, my retirement intimation, my handover letter, all have been part of Form N. Pursuant to that, my lord, Form N was received by the officers of the Labour Commissioner on 19th of November 2024. Thereafter, my lord, annexure G at page 54 is the reply. Page 54, man. Page 54 is the reply of the AGMC.
Yes. Then
Might not be preferred our reply at page 55. Its reply might not be preferred.
then
Now we are waiting for the Assistant Labour Commissioner website whose powers under section 7(4)(a) of the Payment of Gratuity Act, which is not done so. So this petition will file, waiting for the Honorable Court's direction. We issue direction to the agency to discharge the obligations under section 7(4)(a) and decide whether the quantum of gratuity payable to be is correct or not. That
what is the I?
this I might not happen this. The Assistant Labour Commissioner, which is completed, was party is number 3 in the repetition, my lord. He happens to be a creature of the central government. He happens to be a creature of the central government. Assistant Labour Commissioner Central. So I used filed the IA for impeachment of the Assistant Labour Commissioner of the state of Assam as respondent number 3A. There was a mistake on my part, my lord, because the ALC, there are two ALCs in the state of Assam. One under the state government and one under the central government. I mistakenly erect the central government.
Why respond number 3A?
Because 4 is Puma respondent, my lord. AGMC, my lord. AGMC, I've made that Puma respond number 4. For continuity, my lord, I've stated as 3A.
The 3A cannot be, it can be 3.1.
3.1, my lord. 3.1. That is the extent of my prayer.
It is an application filed for impeachment of the opposite party herein as respondent number 3, capital A, to the accompanying petition. Taking into account the reasons were assigned and the necessity for adjudication of the present dispute, this court impledes the opposite party number 1, opposite party in the instant application as the respondent number 3.1 of to the petition, to the accompanying petition. The counsel appearing on behalf of the petitioner is directed to file a fresh memo party before the registry of this court, and the registry shall, on the basis of the present order, as well as the memo parties, make necessary changes in the course title and update the same CIS I disposed. Matter is pending before whom?
Labor Commissioner, madam.
Whom?
Madam.
Which Assistant Labor Commissioner?
That.
Is it the central or the
State.
so therefore, why you should have asked for striking out three and substitution of three? Taking into account the issue involved, wherein the opposite party is actually adjudicating the dispute between the petitioner and the Assam Government Marketing Corporation Limited, and not the respondent number three to the petition. This four substitutes the opponent party herein as the respondent number three to the accompanying petition. The original respondent number three is struck off from the aerial parties. There is the left counsel appearing on behalf of the petitioner and killing. So therefore, it will be now three. Now, what does number two have to do? Yeah,
Madam, they are not the necessary.
unnecessarily you have made.
So I.
But Mr. Counsel, tell me, if it is the state, why you are making one and two a party? Why the state of Assam is not a party? Then, Mr. Counsel, you have to withdraw and file a fresh one. You have to file a fresh one. You have to make the state government a party. In the state government order, Chief Commissioner, Labor Commissioner said, yeah, because the dispute is, you can withdraw. Mr. So-and-so submits that there are certain formal defects in the writ petition, and therefore the petitioner would like to withdraw the instant writ petition without prejudice and liberty to file a separate writ petition by removing the formal defects. Taking into account the above, the writ petition therefore stands closed on withdrawal. Liberty is given to the petitioner to refile by removing the formal defects. I stands closed. Go please. Will this a non-payment one? The notice issued for you returnable on 7th of September. Mr. Bokal, you are paying for all. For 7th.
Payment of. It's not forfeited on the previous of the yes, one of the ratings because it's still my pass.
Police. Police. Is it police?
Yes.
7-9. Notice should 7-9 take steps. Yes, to people. You see the order takes for Mr. appeal for the orders.
Office.
Yeah,
The method of contemplated promotion from grade 4 to grade 3, wherein in spite to senior, has been not been considered.
right.
Which of the gradation list statute plan? When is at page 21.
The relevant.
Who have been promoted?
Page 23.
All are junior to you?
Yes.
7, 8 and 9.
Yes.
All are junior
Yes.
to you. Where?
Now, but then, I filed an RTI seeking the board resolution promotion that was not.
How many persons are here? Petitioner?
2%.
Person.
And respondent,
And where are the gradation list?
yes, but at page 21 it starts, page 23.
Where? With the name of the patient
Size,
Itu Sharma and
Pitu Sarman, of P. Rongsina Talk.
huh? There. You won't find their name.
Yes, yes, Lordship,
Yeah,
page
no.
27. Huh? Page 25, Lordship.
He's number 6. Number 6 and number 8.
Number.
And what are the petitioners here? Other respondents are?
At page, Lordship, 27.
Where?
Abdul Sattar, Vidinsi Kumar Sotia, at 1 and 2.
And promotion to which post?
Lordship, grade 3.
Where?
Lordship,
Where is the promotion?
Lordship, promotion order, I filed RTI. I filed RTI appeal also, that was not provided. I only saw it in the notice board. The RTI applications I have annexed and also the replies.
You are Zarika.
I
You are
was
Jarikar.
initially appointed as interpreter and office peer. Thereafter upgraded to Jarikar.
And what have these people begun?
They were peon.
No. What is the promotion given to?
Grade 3, Lordship. I have not got the orders. I have got the date. Therefore, I have put the date in the prayer. But in my RTIs, they have not provided the copies.
You are grateful, Zarika. And what is the promotional scope from Zarika?
Okay, grade 4 posts. Nowadays, it is process server.
This is the post of process server.
Process servers now, in the latest, in the nomenclatures were changed. The Jarikarak were changed to process server.
Okay. Now which upper division?
To the upper division, from their lower division now.
You sure?
Promotion to the upper division.
No, this is the postal fitting to the lower division, LDA.
This is now LDA.
You are grade 4.
Grade 4 to LDA, sorry, Lordship. Grade 4 to LDA.
It is the selection on the basis of seniority come merit from amongst the grade 4 staff of the chief judicial magistrate concerned who have passed a HSBC or equivalent exam and later 7 years of coming in the chief judicial the first day. You have 7 days, 7 years.
Lordship, we are appointed in 2013.
So how do you know that there has been a promotion?
Lordship, it was stuck to the notice board, but I filed our RTI application seeking the resolution.
There are some defects in the instance. Now, you have earlier also filed similar application.
Lordship, what has happened, the date in the prayer was wrong, therefore we.
Now what is your prayer? So you have putting an arrow in, you don't know what has happened. You don't have the promotional order, nothing.
Lordship, I have filed RTI, Lordship, RTI application, I have annexed.
Promotion order dated 28/2024.
Yes.
That you are challenging in the year 2026, why?
Lordship, yes, we filed the RTI. The RTI reply ultimately was not given. The final RTI reply was given on the
Where is your
in September 2025.
Where is your RTI?
Yes, at page 29. Final RTI is at page 33.
What is the information you are asking?
29 and page 30.
What are you asking for?
Name of the board members, the resolution orders, lordship, particular 5. Then number 2.
These two vague in information.
Page 31 was the first reply.
So a short for is not specific. Then
Thereafter, the final in page 33.
why you are not asking as to whether these three persons have been promoted on to grade 3 and what is the promotional order? You ask that. Why you are not asking
It's
this?
not the copy of the resolution. No.
What?
Resolution
Where is it?
at page 30.
Resolution for what?
The resolution order copy is taken by the board committee.
Where?
Height, page number 30, serial number 5, subserial 2.
All resolution orders copies taken by the board members. What is this? You know what is to be done. You know that these three persons have been promoted from grade 4 to here who are junior to you. Why you are not directly asking? So therefore, isn't this a fishing expedition on your part?
They are now promoted.
Understood. So they are promoted, you should be asking them. Do you know that they have been promoted or not? Yeah, therefore, they are saying that it is too vague.
Page 33, page 33 again, the rules were provided.
What are the rules? You can get these rules anywhere. Then
They might not, the
long way to no, you should notice and start a roving and fishing inquiry for this. Have you asked how these three persons who were there, we yet only have been promoted? Still get. Then you will get nothing to them. You say that you are senior. So therefore, when these people have been appointed to greatly, you don't have the appointment. Nothing is there. Somebody must have told you, and so you have filed this indefinite or you will without any material particulars you have to ask. They ask at least three persons concerned. Opportunity, this is going to only show the person's trust from the lawyer. First one, he withdraws with liberty. Second one, dismiss. If I dismiss it, his right to do anything goes. With this, I can issue a notice of it.
like, like, do not.
Nothing to know. You should have asked directly. What are you asking? You are filing a case that these response number 7, 8, and 9 have been promoted. Then why are you not asking that point? You don't have the promotion order. On what basis should this court, do you think this court is the inquiry office? Or a court box? So that I will forward it to them and ask them, has these people been promoted or not? And they will come up and say, no, they have not been promoted. And then I'll close the issue. You wonder what we do. Or do you think that the sport in any manner looks like the public information? Listen, you are asking for 226, very difficult like this.
Whatever the statements that they are promoted.
So, well, statement will do when they have been promoted.
Okay,
28, 2024, they have been promoted. So you see that there is an order of 28,000 into promotion order dated there. But why haven't you asked for that? And then why should I? Why, if you know about that, on 28,024 they have been promoted, then why didn't you ask under the RTI then? Why have you moved this court after 2 years? Tell me, give me a good reason for that. If you know that he has been promoted on 28, 2024, because you find that RTI sometime in October 2020.
what a final reply came on September 25.
Not on that, but you filed the RTI on October 2020. So you knew that this person has been promoted on 28, 2024. We don't know. So, would I dismiss it? I dismiss it? No. What should I do? Notice to I won't issue. Then what to do? And I'm not going to ask them disturb the respondents unless I issue a notice. These are the three preconditions for being. You have to do it properly. You have to ask them that we have come to learn that he has been promoted, kindly provide the promotion orders of these three persons. And then provide it and give proper explanation that this has happened, that has happened, and all. And you cannot also be considered to be a fence. So what order should I pass?
I will not be, but after I get a phone.
That I know. But the thing is, how do I pass this order? You don't need to prepare it, but how do I do it? I was a so the building of the government. That we also believe in that. Let counsel appearing on behalf of the petitioner admits that the petitioner being a grateful employee, he was not properly advised to seek the proper information in regards to promotional orders of the respondents. He therefore submits that the petitioner would be well advised to withdraw the instant petition and take appropriate steps before the authorities concerned as regards the promotional orders, if any, of the respondents, and thereupon to challenge the same to advise, taking into account the above, the instant petition stands closed. It is further observed that the withdrawal of the instant petition shall not affect the petitioner to approach this court within a reasonable time if the petitioner, if any right of the petition have been affected on account of the promotion of the respondent number 7 even. What happened?
In questions to the NIT between 1 2026, I submit my tender to my technical is rejected without showing any reason.
Technical be rejected.
Rejected without showing any reason. I asked for my reason. Till now, nothing has been done.
Why? When was it rejected?
Your lordship will find it page, my lord.
143.
146.
143, my.
Improvement technical qualification. Whether technically qualified, no.
But without illegal, but very next day I asked for legal, my lord. Till now, my lord. And my lord, I check it also not yet open. Because of the election.
Now the tender has been, it will now be done with these Macrogem builders and Srimanta Sankardev. So you say that the impugn order of technical rejection is bad. Well, so Mr. Monto, you have come before this court for what? Asking for the reason?
Yes, my lord.
Or is it that the rejection of the technical bid without assigning reason is bad? Which one?
Without assigning reason and does not communicate to me to. So that is a,
Obviously, they have to assign reason, then they will communicate.
even without reason, my lord, that is also bad, my
So therefore, your
Yes.
case is that without reason, they have rejected your technical qualification and then they are progressing with it. And this goes against the Assam procurement rules. Yes.
Clearly,
The technical bit, as per the document enclosed in the description was offline. Sometimes in second of February 2020. Regarding May. My information telephonically whatever I could gather. The financial bid has been offered, the L1 bidder has been referred to the government for final approval. Moment it is work order.
Well, anyway, tomorrow evening, by tomorrow evening, it may happen.
Well, I can place the region and all by tomorrow also we have.
Like 2 o'clock? Give us the minutes. 2 o'clock. Chalo. You will get your reason.
Because there is no such prayer that is the technical bit should be accepted and financial bit should be offered. There is no such prayer made.
Thanks.
No problem.
Give Mr. Mohanto the satisfaction.
Yes,
Give the get the minutes. Photocopy of them. Yes. Down payment. Police. Huh? Police? It's 7-9. It's here. Yeah.
This is regarding demand is of this side. Funding the next, so the local side of the page. Question the kindly see page 21 line exact line.
Yes. Read this.
Page 21 exact line.
Yeah.
My lord, this is the amount they are claiming 9,61,491. And for the period of March 2016 to my lord 12/19. Then my lord, I have paid this whole amount.
March 2016 to 12. This is the undertaking.
Yes, undertaking.
It is your undertaking.
Yes.
Where is their claim?
Claim. But this is the claim, so I have given undertaking. Then my lord, this is paid in Excel for my lord. I have my lord deposited my lord 7 number of checks. Out of that, my lord, 1 check is owner. So I have paid by online. And remaining is owner recovered from the check.
So you paid the entire amount.
Entire amount. My lord, they have this my lord, my lord, kindly say an Excel file.
Have been cleared. Elector page 27.
20, yes, clear.
Yeah.
Then, my lord, again, they issue another notice in 2025, my lord, claiming 83,60,352, my lord, page 89.
This is for the period.
This is for the period, my lord, from 20 to 25.
Earlier it was the period from
It is already, my lord, declared from 0.
2016 to 12, 2019. So this is from June 2020 to March 2025.
Yes.
83 lakhs.
Yes.
So these have nothing to do with the earlier amount. So now
Now, this is also, my lord, they declare, my lord,
my contribution defaulting it has been determined as 0, 0. Kindly see annexer 7 page 30. Because already in 2019 COVID period, my establishment is closed.
Was provided with the alia.
Last one.
Then
Then, my lord,
it happened on 15/10/2025.
25. Now, my lord, proceed kindly come to phase 32 annexer 8, my lord. Now, this is the notice, my lord, recently they saying, along with the statement, my lord, statement is at page 33. Now, my lord, they are claiming damage, my lord, from March 16 to December 2019.
1,50,000.
No, this is the calculation, my lord. Kindly see, my lord, this period and the second column, my lord, this is the contribution amount. Total is 96,544. So, my lord, same statement, my lord, they're calculating 4 times, 5 times, 6 times, my lord.
Where?
My lord, kindly see. This is the first statement for the period of March 16 to December 19. Again, my lord, from page 34, my lord, March 16 to December 19. My lord, same. Page 36, my lord.
So 5 times.
5 times. They are saying, my lord, if I calculated, my lord, this 5 times, my lord, even then my contribution was 5,79,000. If I calculate, my lord, this whole statement, my lord, even then my contribution, my lord, for March 16 to 19 is, my lord, 5,79,000 for 64 only. Already I have paid, my lord, 9,71,000 today. They have already recovered from me. So, my
What
lord, from
happens?
this statement,
Not attend, not required to attend the school hearing if the payment has been made. It's okay. Now, what has happened thereafter?
my lord, already I have paid. Now they are claiming this, my lord, amount 5,79,000 is a damage, my lord, for delay payment.
Did you appeal before them?
My lord, I have already gone that they are not ready to hear anything. My lord, kindly see from this statement also, my lord, if I consider this March to 19, my lord, his damage amount is only, my lord, 96,544.
Now, let us see why they come to court before. So, this is under employee insurance.
Yes.
Let us see under 31. This is done under 31C. 31C.
My lord, it is delay more than 6 months, my lord, then 25%. If, my lord, delay is more than 6 months, then 25%, my lord, interest.
25%.
Percent of the contribution amount.
So therefore, they have imposed
Yes, they already calculated it, my lord.
earlier.
No, this, by this statement.
Then
So, my lord, after calculation, my lord, they consider that 96,544 is the amount, my lord, damage amount. For a period of March 16 to December 19. But I don't know, my lord, why in this sixth statement, my lord, for the same period, they are calculating 6 times.
if for 6%. Yes, but the six.
It is not going to be very clear. Yes, section 75, my lord. It is a not agree. It must be section 75 of the PSI.
PSI,
PSI, same, section 75. The alternative forum is of PSI, PSI.
regulation,
No, my lord, act.
Employees State Insurance Act 1948,
Yes, 48, page 50,
section
the section 75 now.
or 75. Matters to be declared by the employee insurance. Now, against this order, which has been passed on 10/3/2026, 13/3. How do you show that an appeal lies? Order under section 85B of the ESI. No?
And also, Malad, there's section 45 double A.
Understood, 85B, power to recover damages. So against this, an appeal lies, how do you say?
Malad, section 45 double A, Malad.
45.
Malad. Page 31. Whatever the calculations, it's calculated properly. Malad. Section 75. All agreed by the calculation. Damages.
Affidavit of authority. If an employer is not satisfied with the order referred to in section 55B,
Who remedies are available?
so this is an order in terms with 45A, but here the order has been passed under 85A.
And then refer to Malad section 75G. Malad. 75 and 75 Malad plus G. Malad.
55G.
Malad, page 50 of the act. And it can be
Any other matter in which the dispute between the corporation or between the- So it is not an appellate, they don't have an appellate authority, he has to go to the employees insurance court.
Yes, my submission is to oppose the insurance board. This honorable court, for several occasions, something like this, and referred such matters before the employees insurance board. There are a number of orders here, like, you know. If I may notice one such matter.
What? What to do? Go there, to the earlier.
My daughter, okay, one my daughter, till date, my daughter, no recovery, not my account. Now, already, my lord, I have paid more than their demand in 2025. My lord, 9,75,000 I have paid as per their demand. My lord. Now, if I calculated this statement from their statement, it reveals that my contribution has to only 5,75,000. Now, they have already recovered from me 9,71,000. I have already paid. Now, they are, my lord, if I have paid, my lord, 9,71,000.
Recovery at areas of land rating.
My lord, that is, my lord, this is only damage. They have given me damage.
How will they recover? They will recover it at areas of land revenue. Areas of land revenue have to be done. Yeah. Really?
My lord, is yes, my lord.
Go to the passenger office. We have seen the passenger officers are the slowest of all. But don't worry with that. You go and buy an appeal.
You may also get the injunction there. Huh? You also get the injunction there for the person.
You can get the injunction. Art Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. M. Smith appears on behalf of respondent number 1, 2, 3, 4.
Private seats have been implicated personally. Right?
4. Taking into account the order which the court proposes to pass, this court dispenses with the service upon the respondent. It says. The petitioner hearing have assailed the order dated 10/3/2026, by which the regional director, that is the respondent number 2, have passed an order in exercise of powers under section 85 capital B of the Employees State Insurance Act 1948, thereby imposing an amount of rupees 5,79,264 as damages for the wage period from 1/3/2016 to 31/12/2019. It is the case of the petitioner that for the period from March 2016 to December 2019, a total amount of rupees 9,61,491 was payable. In pursuance to directions issued, the petitioner duly paid the said amount, and from the perusal of the order dated 3/7/2025 issued by the respondent number 3, respondent number 4, it would be apparent that there was no outstanding dues payable by the petitioner. The legal counsel further submitted that for the period from June 2020 to March 2025, an amount of rupees 83 lakhs, 8,36,000 how much is it? 83 lakhs.
83 lakh.
83 lakhs 60,352 was held to be payable by the petitioner. However, the said order was, however, upon appearance of, however, the petitioner, upon explaining to the authorities concerned, the respondent number 3 categorically held that for the period from June 2020 to March 2025, there was no payment made payable by the petitioner. To the shock of the petitioner, that a notice was received, a notice dated 18/2/2026 was received from the respondent number 2 to appear before him and explain why damages to the extent of rupees 5,79,264 is not payable by the petitioner. Pursuant thereto, an order was passed on 13/3/2026. On 10/3/2026, which was digitally signed on 13/3/2026, thereby imposing a damages to the tune of rupees 5,79,264 for the period from 1/3/2016 to 31/12/2019. The learned counsel, appearing on behalf of the petitioner, submitted that there is no amount which the petitioner is liable to pay. In fact, the petitioner had paid more than what is required as per the ESI Act 1948. Mr. N. Smith, the learned counsel, appearing on behalf of the respondents, submitted that the order as to whether the petitioner is liable to pay or what amount, and or there has been or the fact that the petitioner had paid more amount are questions of facts. And in that regard, as the petitioner has an alternative and efficacious remedy before the Employees State Insurance Board, the Employees Insurance Board, in terms with Section 75G, small g, of the ESI Act 1948, this court may not like to entertain the instant petition. This court has given an anxious consideration to the respective submissions and taking into account the claim the petitioner that the petitioner is not entitled to, is not liable to make a payment, or the fact that the petitioner had already paid more than what is required in terms for the period from 1/3/2016 to 31/12/2019, are questions of facts which can be best addressed before the Employees Insurance Board, wherein facts can be adequately dealt with. So taking into account the above, this court is not inclined to do so. Furthermore, it is very pertinent to observe that the disputes which have been raised in the instant proceeding, particularly the challenge to the order dated 10/3/2026, which was digitally signed by the respondent number 2 on 13/3/2026, can be adequately redressed by the Employees Insurance Board in terms of Section 75G of the ESI Act 1948. Accordingly, this court therefore is not inclined to entertain the instant petition. The petition accordingly stands dismissed. This one. Before parting with the record, this court, however, observed that the dismissal of the instant petition shall not prejudice or preclude the petitioner to approach the Employees Insurance Board in terms with Section 75(3) of the ESI Act.
My lord, under section 45C. Now they can, my lord, attest my business.
Only know what to do. I can pass an order when I'm not at the TV.
Obviously.
Somebody has done. It's not well. Who is preparing for the other side? Mr. Dean Nath, where is he? The petitioner is not well. Yes, regards the status of consideration of the proposal dated 17/8 purportedly submitted by the swear. We don't think
I should be able to get hold of that proposal, my lord. That proposal is my lord furnished to me. The
who
order,
years,
yes,
2 years we have not been able. And what about the other person, Mr. Deena?
that has come from my lord, as per the submissions made by the Ladek Council, that proposal was sent my lord by the PWD department. So it is from government to government, my lord. I inquired with the finance department because that contact proposal number which was getting furnished to me, my lord. So that is my predicament, my lord. In that particular order, proceedings, my lord, the proposal is stated to have been, my lord, kept as a part of the record with market legal action.
It says that it was sent on 17/8/2024.
But the exact proposal number and my lord, the details have to be, my lord, furnished to me.
Let us have the chief secretary, the deputy secretary to the government of Assam Public Works Department present.
It can get all, my lord.
Not necessary, I think you people,
All about the components, my lord.
it appears that So this court have heard the learned counsel the hearing on behalf of the party. And I have also viewed the materials from the court, more particularly the order dated 25/9/2024. It is very pertinent to take note of that the instant contempt application has been filed alleging willful and deliberate violation to the order dated 28/3/2023, passed in the frequency number 381 of the 2014. When the contempt application was taken up on 25/9/2024, Mr. Dipankar Nath, the learned standing counsel of the PWD-R, have submitted before this court that the proposal have been placed before have been sent to the Finance Department, Budget Department on 17/8/2024. So under such circumstances, this court had requested Mr. R. Bapudari, the learned standing counsel for the Finance Department, to obtain instruction as regards the status of consideration of the proposal dated 17/8/2024, purportedly submitted by the PWR Assam. Mr. R. Bapudari, appearing on behalf of the PWD Department, Finance Department, submits that after a lapse of more than 18 months, that they have not been able to track the proposal, taking into account that the proposal number have not been provided. It is also seen that none has appeared on behalf of the PWD-R department. It is also seen that none has appeared on behalf of the Commissioner and Secretary and Special Secretary to the Government of Assam PWD-R Department, as well as the Chief Engineer PWD-R Department. Considering the above, it appears therefore that for the last 18 months, the instant contempt application has been pending, and there has been no interdepartmental correspondence. Thereby, the directions which have been passed by the court in the order dated 28/3/2023 still remains uncomplied. Considering the above, this court therefore directs the Chief Engineer, PWD-R, Sam, to be present in the court on 15th of May 2026 at 10:30 a.m. The council from PWD. The council. Mr. R. Bapudari, Mr. K. Gogoi, the learned additional senior government advocate, shall intimate the Chief Engineer PWD, R. here to be present and provide the video link, video conferencing link. God bless you. Mr. B. Gogoi, will you inform or I'll ask him? Be present at 10:30.
Yes, I hold on. Speaking order has been passed. And speaking order has been passed in this case.
Pursuant to the order passed by this court, Mr. and by this anyone has to obtain instruction whether the verification directed by this court to be carried out. Yes, what?
But I did not receive the copy of this being ordered. Let it be on behalf of tomorrow.
You have not
Because
received?
What? Because the concern was with the concern dealing assistant and which is the technical. Therefore, tomorrow not I will process. You take one month. Your lordship, you take lordship, just yes, not.
Okay. We only want this thing.
Yes.
This matter again on 15/5/2026. In the meantime, Mr. Anupai, the Linux Standing Council of the Irrigation Department shall provide as to whether the verification as directed by this court and whether the verification of the amount payable to the petitioner have been carried out or not. Not. And if no verification, will initiate contempt proceedings.
In fact, what is speaking order has been passed. Speaking order has been passed.
Yes. Yes, but is this Kumoto who has taken?
What has been responded, madam, we have tendered apology. This person has been shunted out and is due to retire in this year, madam, in the month of November.
Who is this person?
That time he was serving as a CFO of a division, madam, Gauhati. And that very petition order was essayed in a written appeal also. When put in.
So if between the Sumoto proceedings has been done against whom?
Uh,
Rohini Kumar Da. You are appealing
Yes.
to him.
Yes, really.
Now what has happened?
Malak, we have filed an affidavit in which we are tendering unconditional apology. Malak, what has happened? Due to some
Why was this order passed for a year?
Order is that six hundred connected.
Huh?
The interim order was violated.
Interim order was violated.
One
Which order?
interim order, this is quite department is nice order.
Now let us see the order by which the initiation of contempt was done.
Yes, but
Which order?
it's
that is it. Is 22. That is the 8/23.
That is a final order.
yes, Malak, final order, Malak, while disposing the petition minutes, this Sumoto content was direct to give a respect against him.
Well, let us see the
That is what court is of Maya. I got happy.
It's one.
so both the petitions are disposed of by the of the order. Where is the affidavit?
Malak, we are taking it down.
Where's the order dated 2/11?
211, I have annexment. Map.
Where?
In my affidavit, annexure B1.
Where is the annexure? Next one?
Annexure B, man.
Now, there was this interim order not to proceed further with the tender process.
My lord will find that.
Page 55. The last line, in the interim, the respondents in our shall not proceed further with the tender process in terms with the long e-auction notice dated so and so, dated issued by Iman until further order. Now, you mentioned that it was already the work order
Yes, my
was
lord, then
issued.
we have a 54.
Okay?
54, my lord, the bottom portion I have submitted. The letter we cannot.
The letter has been issued in favor of VIA, but the respondent have not yet handed over the possession of the mall to the said person. Agreement has been signed for it. Now, did you sign the agreement thereafter?
No, my lord, there's no signature. It was not signed. He was just called to come and sign. And then immediately we came to know, my lord, we stopped it.
So, was there any handing over
No,
the
my-
possession? Nothing.
Nothing.
And there was neither any handing over possession nor any signing of agreement till the final judgment was pronounced. Isn't it?
Yes.
Because heard Mr. G. Bashir, Senior Counsel and Standing Counsel of the Gauhati High Court, Senior Counsel, and the Standing Counsel of the Gauhati High Court, assisted by so-and-so who appears on behalf of the Gauhati, and assisted by so-and-so. Mr. T. Gogoi, the learned counsel, appears on behalf of the contemner. The present contempt application have been initiated sumoto on the basis of the directions passed by this court in the judgment and order dated 8/12/2023. The reason as to why this court, the learned court bench of this court had observed that it was necessary for initiating a sumoto contempt proceedings against the contemner can be seen from paragraph number 36 and 37 of the judgment and order dated 3/12/2023, 8/12/2023. The said two paragraphs are reproduced hereunder. Next. It is further relevant to take note of that the above observations have been made by the learned coordinate bench in the judgment and order dated 8/12/2023 on account of a violation of the order dated 2/11/2021 passed in WPC number 5728/2021. A perusal of the said order dated 2/11/2021 and more particularly at would show that there was a specific direction passed by the learned coordinate bench. Certain interim directions were passed by the learned coordinate bench, thereby directing the respondents in the forest department not to proceed further with the tender process in terms of the long e-auction notice under NIT number .NO FDMT B Mohol General oblique 2021 oblique 1716 dated 11/6/2021 issued by the DFO Dhemaji Division Dhemaji until further orders of the court. It is, however, very relevant to take note of that in the said order dated 2/11/2021, the learned coordinate bench of this court had also recorded the submissions were made by the council, standing council appearing on behalf of the forest department, that a letter of intent, however, had already been issued to the respondent number 5 in the said proceedings. But the respondent forest department had not handed over the possession of the said mohol to the said respondent, have neither handed over the possession of the said mohol to the said respondent, nor agreement have been signed, for that mohol, as environment clearance for the said mohol was yet to be obtained and acceptance of the mining plan of the same have not been completed. It is further seen from the affidavit which have been filed by the respondent by the contemner in the instant proceeding, is that there is no, that pursuant to the issuance of the work order, pursuant to the order dated 2/11/2021, nothing further was carried out. Inasmuch as neither the possession nor the agreement neither the possession was handed over nor the agreement was signed with the respondent number 5, isn't it?
Yes.
First, till Mr. D. further submits that till the judgment was not pronounced on 8/12/2023, nothing further was taken. So this could have also taken note of the affidavit filed by the alleged contemner to the effect that whereby he had tendered his unconditional apology whereby he had not only tendered his unconditional apology but have also purged the contempt. Wherein he had purged the contempt and thereupon have tendered unconditional apology. Taking into account the above, it is the opinion of this court that the further continuation of the instant contempt proceedings would not be in the interest of justice. Accordingly, accepting the tender unconditional apology, this court, tendered by the contemner, this court, in the interest of justice, closes the instant contempt proceedings.
Seeking extension of time. Seeking extension of time for filing a review petition, which your lordship has granted by the judgment dated 25 past CRP 101 of the team. Well, by that judgment, your lordship has granted 30 days time to court to notify the review petition. However, the applicant was intimated about the order only after 1 month of passing of the judgment. Others two similar, your lordship has also allowed by the election deadline is at page 214 now.
Why do you want an extension of time?
Why not we could have approached in 30 days time as per the granted by. So
Then
well, limited
30 days of time was given from
25, 25. 1 month from the date of the judgment, ma'am. 30 days.
25/3/2025.
30 days. We were
Now it has almost been 1 year. When did you file this application?
filed. There are 3 IAs in similar ballot. The 2 Lordship has additional time.
Huh?
There are 3 IAs in total. One of another 2 similar IA, your Lordship has
My
granted.
question is, when did you file this application?
Last year in the month of July.
16/7. The period ended on 25/4.
Yes.
Why did you file on 16/7?
Why not when we approached November 4th in the month of after the because we were intimated about the passing of the judgment only after 1 month of the passing of the judgment.
Huh?
Why not kindly come to page 214?
2 hours.
Why not?
Okay,
not
we
make a-
impose the cost of 10,000.
Why not kindly come to page 214? Why not in other 2 similar IA, why not has already allowance?
Okay.
Why not kindly
20,000.
kindly consider another 2 similar matter? Why not has grant us additional time?
When was this application filed?
What's
Same day.
Same day.
Between is now, right? Then you can file it by day what?
Why not give us 30 days time? 30 days time.
No. 5 days.
Kindly, my lord.
5 days.
Kindly, my lord, 30 days time, my lord.
No, why do you need 30 days? You know it. This matter has been pending for all this while. We have not prepared the review application.
Why not kindly 10 days, my lord?
Huh?
10 days, 10 days.
10 days. We can take.
Wait, my lord. There are certain developments which have taken place, my lord. Cause of the petition.
You get the contract.
Yes, my lord. The period of contract is over, my lord. The period of contract is over. The tender process is also over, my lord. And the petitioner also, in the meanwhile, were awarded certain work orders were also given to the petitioner. So he has also completed his part, my lord. And the cause which he has ventilated before the lordship.
Withdraw.
Yes, my lord, we withdraw this petition.
State. Preparing behalf.
My lord, there is a connected writ petition also that can, my lord, there is a connected writ petition also.
We are also withdrawing the collected petition.
The petition has already been closed.
No, but there's another writ petition, my lord.
Yeah.
With the IA, and there is writ petition number of 4260, my lord.
Where is that?
My lord,
It is
was,
listed today.
yes, my lord, it is listed today,
Where?
along with, my lord, 4106. একেলগে আছে দাদা, একেলগে আছে ফাইলটোতে আছে অহা নাই ন এনিৱেজ মানে আছে
This is this IA only in respect to 4106.
yes my lord
That is the matter which is before me.
yes my lord but
The
in
other petition was withdrawn.
my lord yes my lord
And then it is only in
I'm applied
that one I have dismissed this. Oh, hey, I dismissed it.
Sorry, there is an IA.
Just wait. Dismissed. You for non-compliance with what order?
Please, very good.
Why haven't you paid? Why haven't you paid?
Lordship instruction is yet to come. Instruction is yet to come.
No instruction. Why haven't you paid this amount? There was an instruction given by the, there was an instruction placed that saying that respondent have fully admitted 18,19,095. Taking into account the above, this court therefore disposes with the direction here to pay the same additional admitted here after making the pay shall be done within a period of 6 months. After giving you 6 months, why haven't you paid? Who is to pay?
Account number 3, therefore account number 3.
Hmm?
Well, there is an affidavit but in the record just for now years back
So you got 1 lakh. 1 lakh has been paid.
Yes, sir.
It is not 18 lakh 19,000, it is something like 17,000.
17,000.
47,000, 17 lakh 47,000. And 16 lakh 5,184 is pending. Is an application filed for willful and deliberate violation to the order dated 11/8/2025 passed in deputy number 5145 of 2024. A perusal of the order dated order dated 11/8/2025, passed in WPC number 51445/2024, showed that on the basis of certain admission, on the basis of an enclosed document being produced by the respondent, by the government advocate, wherein it was duly admitted that an amount of rupees 18,19,095 was payable. This court directed the respondent authorities to make payment of the said amount within a period of 6 months from the date the certified copy of the order was served upon the respondent number 5 therein. It is further seen that pursuant to the order dated so and so, passed in WPC number so and so, the said order was served upon all the respondents. Was served upon the Commissioner and Secretary to the Government of Assam Finance Department, the Assistant Inspector General of Police Administration, as well as the Superintendent of Police Lakhimpur. In pursuance to, as there was no compliance to the order passed by this court, the petitioner have been compelled to initiate the present contempt application. A notice was issued on 25/3/2026 by this court. Pursuant thereto, Ms. So-and-so appears for respondent number two.
On behalf of
You appear for one. He appears for one. You appear for 2 and 3. 2. Insofar as respondent number 3 is concerned, a communication has been forwarded to the Registrar General, Deputy Registrar, Gauhati High Court, dated 22/4/2026. From a perusal of the said communication, it was found that the actual entitlement of the petitioner was rupees 17,47,419. And out of that, an amount of rupees 1,42,235 have already been paid. And in respect to the balance amount of rupees 16,05,184, the additional secretary to the government of Assam, Home and Political Department have been informed for providing the financial sanction on 17/4/2026. Considering the above, this court fixes the matter again on 22/6/2026. It is observed that if the amount of rupees 16,05,184 is not disbursed to the petitioner in the meantime, this court could be constrained, may consider imposition of interest upon the concerned respondent departments on the said amount of rupees 16,05,184, and such interest thereupon would be payable by the concerned respondent departments and recovered from the salary of the erring officials, including yours.
Please, Your Lordship, my lord.
Yes,
Lordship,
very good.
So Lordship presents the order dated 28/4/26, my lord, passed by the Lanet Loajima Court, my lord, services.
Service upon the respondent number 6, 4 and 6 being complete is the matter for admission on May 2026,
Right.
on which date this court shall hear on the question of maintainability.
Right.
Please, your lordship.
What is this?
Lordship, as per the
Item
order
number?
date 2018. For the
What
order
is this?
date 28/4/26.
Service upon response number 4 is complete. Looks good. For approval of the order dated 28/4/2026, passed by the learned lords of the court. The service upon the respondent number 4 is complete. Considering the above is the matter for admission on 17/6/2026. What is the matter about?
It's the non-payment of my bill amount. The non-payment of my bill amount, the invoices were raised.
What bill?
I'm a MSME registered enterprise. So I have supplied some materials to the respondent number 4. Thereupon, your lordship, the matter was, I have filed a complaint under the MSME Act, the section 18, before the MSME Council. Therefore, your lordship, what has happened for the mandate of the section 18 of the Mediation Act, it states that the mediation is to be completed within 120 days. In pursuant to that, even after 19 November 2022, I filed the application. And thereafter, the case was registered in the case, it was registered in the case. And after that, your lordship, after repeated representation before the council, they did not issue any notice for my appearance. And after the case was filed before the
So your basic question is that the MSCB Facilitation Council have not taken appropriate steps for disposal of your proceedings under section 18. That's your case. So
but your lordship, if I make this,
that's your case.
your lordship, what has happened after the case was filed here? The government advocate has given a parallel reply where it stated that the case was disposed on 21st of May 2023.
Where like yeah. You know me?
And the case
In Agarwal. No, this has been closed.
This is my attention here. I was never informed of. I was never informed of.
But you have to challenge that. How do I exercise my jurisdiction? Because your entire prayer is for disposal of that. So if it has already been disposed of, how do I revive it? Unless you challenge that.
If I may, please before Lordship, Annexure 7, if your Lordship, you see Annexure 7,
Okay?
page 61. 61. Your Lordship can kindly see, the date of application is 19 November 2022. And, hearing date is 16 February 2024. Your Lordship, this is the status. If the only way which a applicant is intimated regarding the hearing, this is the online platform. And I can only check online, Your Lordship, because no notice was served to me, not even an email. So this is the status, Your Lordship, as on 14 July 2025, Your Lordship.
No, understood. But Mr. Council, my question is, let me challenge the minutes of the 17th meeting. Wherein, the 17th or the 17th meeting, wherein it has been closed. You have to challenge these minutes.
Because Your Lordship, what has happened?
Mr. Council, am I not clear to you? Are you not required to challenge this? What is your prayer? You have come out here and asked that kindly direct the MSME's council, facilitation council to dispose of the matter. Now, as of now, the matter has been already disposed of. And on 21/5/2024. So if it has been disposed of, are you not required to challenge it?
Yeah.
So therefore, keeping this matter pending if means nothing. You have to challenge it, then you have to revive. Or do something, file an application for revival. I give you the opportunity to do that.
Get off.
Heard Mr. So the Leland Council appearing on behalf of the B. Vocally appears on behalf of the respondent number 2, 3. Appears for the respondent number 5. None appears for the respondent number 4, although the service is complete. The petitioner herein has approached this court seeking a direction upon the respondent number 2 to dispose of and conclude the case bearing number AS/22/S/ASM/00246, which have been pending before the respondent number 2 within a specified time by giving an opportunity of hearing to the petitioners. The record reveals that pursuant to a notice being issued by this court on 11/2/2026, instructions were placed by Ms. Eudax on the learned additional senior government advocate on 25/3/2026. The same instruction was be it as it may, today also Mr. B. Bokel, the learned counsel appearing on behalf of the respondent numbers 1, 2, 3, and 5. 1, 1, 2, and 3. Have again placed those instructions, have placed emphasis on the instructions dated 25/3/2026. These instructions are kept on record and marked with the letter X. From a perusal of the said instructions, it is seen that though the petitioner had filed an application which before the respondent number 2, which was registered as Samadhan case number AS/22/S/ASM/00246. But on account of non-appearance of the petitioner, as well as the respondent on 2 consecutive dates, in the meeting held on 21/5/2024, the application so filed by the petitioner was closed. The learned counsel appearing on behalf of the petitioner submitted that there was no information provided to the petitioner about the date being fixed on 21/5/2024. He, however, submitted that the petitioner, that in view of the closure of the case which have been filed by the petitioner on the basis of the minutes of the meeting, 17th meeting of the respondent number 2 held on 21/5/2024, the petitioner would be well advised to take appropriate steps against the minutes of the meeting dated 21/5/2024. He therefore submits that the petitioner would not like to pursue the instant proceeding without prejudice to his claims made in the instant proceedings. Taking into account the above, the petition stands closed on withdrawal. It is observed that the withdrawal of the instant petition shall not prejudice the petitioner for seeking appropriate remedies against the closure of the case being so and so on the basis of the minutes of the 17th meeting of the respondent number 2 held on 21/5/2024. We have a copy of X. The petitioner. Take a photocopy from him. X. Mr. Bugel, you have a copy of it. Or you give it to you. Huh? What is this? 19.
I am appearing on behalf of Mr. N.K. Kolita Mailer, who assists the court Mailer, as per office note dated 5/5/2026 Mailer. Although ID card not returned, but the consignment tracking Mailer was delivered Mailer.
Service complete.
Yes, ma'am.
Service being complete, it's the matter for admission on urgency, no urgency.
Mailer, payment, non-payment of bill Mailer. They may be fixed.
On payment against whom you are asking? Why are you making all these people a party? Huh? Why have you made this person the respondent number 6 a party? Tell me.
Actually, I'm appearing on behalf of the. So I may.
Admission
They
on
may fix.
15th of June. 1st of June 2000.
Then it will take another today or tomorrow.
Just the minutes. We'll choose the matter, give him the minutes, and he will then withdraw with liberty to file. What is this?
May I plead the lots of ballot notice will be issued and if not, payments may not be. Service is complete.
Service is complete. No?
Yes,
Service being complete, it's the matter for admission on urgency, no urgency.
little bit of because this is regarding that boat market, shifted from Bhutnath to Tulipar in a very unhygienic condition it is operating, the excessive fees has also been collected from the
And the matter be fixed for admission on 25th of May 2001. Right. IA for lots of delay. 340. Have you filed a review? Yes. Okay. Review on dismiss to review, IA on whether I not lots of taking into account the order being passed. Right? This is the review. Review similar lots of. We condone the delay and I review discussion. I remember register, I think that order also mentions there, no? To register. There's some other case. At that time, lots of 6 of the review. So it will be. In the Gymkhana Club for case group, at a order this. I dismiss allow also, condone for it. Review to register with I in terms of review fund, that allow also can review dismiss. Review register for it dismiss. দুখন এপ্লিকেশন হ'ব দিছপুৰ এখন আই হ'ব এখন ৰিভিউ এইখন কণ্ডোন কৰি
IA for correction of the order, my lord.
what happened
My lord, kindly see page 8, my lord. Paragraph 6, my lord. There is respondent number 3, 6, and 7, my lord, but there is no respondent number 3, 5, 6, and 7.
Huh?
Only 4 respondents are there, my lord.
wait.
My lord, paragraph 6, my lord, page 8, my lord.
So direction is they are thereby directing the respondents, more particularly respondents need to verify the entire case. What?
And next, my lord, in last line, my lord,
Respondent is respondent number 2,
2 and 3, it should be.
2 and 3. Okay.
And last line, my lord, respondent 5, my lord, it should be respondent.
I didn't responded to respondent number 2. 2 man. This is an application filed for. Why is the BTC here?
My lord, it wrongly supposed.
Huh?
BTC, my lord. There is no BTC, man.
Hey, don't think to the man. How is this possible? How is it possible? Huh? BTC को पाएंगे. It's not a question of correction. We recall this order.
We have not taken any.
Apparently, it is a mistake committed by this court. We'll recall this order and then pass another order. Okay?
We have not taken any certified copy.
That's okay. But it is an apparent mistake committed by me. Therefore, so pass is responsible. Mr. Soliha. And where is the PWD? You are PWD also. Finance. Oh. Mr. Gugoi, there is a mistake. In fact, this is a case of non-payment of the dues for that PWD. My stenographer, in fact, I won't say them. My mistake. I put the BTC and all the things. But So therefore, we may recall this order which was passed and then pass an order as per Kamsar Ali to make the payment. This is an application file for correction of the order dated 8/12/2025, passing WPC number 5042 of the 2025. Is the amount okay? Okay. Whereby there were certain directions issued upon respondents by this court. Directions issued upon the respondent number 3, 6, and 7 by this court. Although in the writ petition there were only 4 respondents. Further to that, in the said order, there was a apparent mistake committed by this court in referring to the Standing Council of the BTC, or the BTC, Standing Council of the BTC, though the Bodoland Territorial Council was not a party. Taking into account that there has been gross mistakes committed by this court in passing the order dated 8/12/2025 in WPC number 50, the accompanying writ petition, and the well-settled principles of law to the effect that on account of a mistake committed by the court, the party should not suffer. This court recalls the order dated 8/12/2025, passed in WPC number 5042 of 2025. The writ petition being WPC number 54042 of 2025 is therefore restored back to the file of this court. I stands disposed. Main chronology. Give a hard history, change to Mr. Keudin, the learned counsel appearing on behalf of the petitioner, Mr. D. Gogoi, the learned additional general, as well as standing Assam, as well as the standing counsel of the PWD department, and the ACB, the learned standing counsel of the finance department. The petitioner herein is agreed by the non-payment of an amount of rupees 1,78,042, which the petitioner claims to be payable to the petitioner on account of various supplies of the stock of office stationery materials to the respondent authorities. It is the further case of the petitioner that after making the supplies to the satisfaction of the respondent authorities, the respondent authorities have also admitted the said amount and have also made a demand proposal in respect to the amount payable to the petitioner. However, an amount of rupees 1,78,042 is still pending. The petitioner had submitted various representation to the concerned respondent authorities, but the responding authorities have turned a deaf ear to such representation. It is under such circumstances the petitioner is compelled to approach this court by filing the present petition. The record reveals that this court had issued notice on 15/9/2025. However, there was no affidavit filed by the respondent authorities as to whether the petitioner is entitled to the amount of rupees 1,78,042 as claimed by the petitioner. Mr. B. Gogoi, the learned additional advocate general, as well as the standing counsel of the finance of the PWD department, submits that as to whether the petitioner was issued those work orders and whether the petitioner had thereupon made the supply, and further as to what amount the petitioner is entitled to, are questions which will require certain verifications to be carried out. The learned advocate general, additional advocate general, have further submitted that the PWD department, in the PWD department, payment is also made by following the mandate of the full bench of the court in the case of Tamser Ali versus so-and-so, reported in 2008 4 GLT 1. This court have heard the learned counsels appearing on behalf of the parties and have also perused the materials on record. It is the opinion of this court that if the petitioner have duly made the supply pursuant to a work order being issued or work of the oblique supply order having been issued, the respondents cannot deny such entitlement of the petitioner. However, as to whether the petitioner is entitled or not is a question to be verified by the respondent authorities. Accordingly, this court therefore disposes of the instant petition with the following observations and directions. The respondent numbers 2 and 3. Number 1 day. Number 1. Okay. The respondent number 2 and 3 are directed to carry out the necessary verification as to whether the petitioner is entitled to the said amount of rupees 1,78,042 as claimed in the instant petition, or to any amount in pursuance to the work orders so issued, supply orders so issued. It is further observed that the respondents shall also ascertain as to whether the supply orders have been actually issued to the petitioner. So this verification be conducted and completed within a period of 2 months from the date a certified copy of this order is served upon the respondent number 2. Next. This court further directs that upon verification, the payment has to be made by the respondent authorities in terms with the mandate followed, in terms with the judgment of the Supreme Court, of the learned full bench of this court, in the case of Tamser Ali Supra. What is this?
Is the petitioner is aggrieved by marking of T. The petitioner was declared as not to be foreigner, Indian by the Foreigners Tribunal also.
Huh?
The petitioner was declared to be not to be foreigner, Indian by the Foreigners Tribunal Lordship. So she has come forward that despite that, he has been marking of T in for the electoral lordship. So Lordship has the earlier also directed the flex steps Lordship, and since he has approached after the voter political conduct has come into force. So after the process of election will be over, we are directed to take steps. Accordingly, we have taken.
Election process is not over. Then it was over on 4th. We are today on 11th. Long time.
On 8 itself, we have given the direction.
You don't have a election commission now has no other work. Still 2029, no other work. So do some good thing for the people.
Yes, sir, we have already taken the steps. Good thing.
Don't change the name. Moving the D, how much does it take? You need a gazette notification. Then
Couple of weeks, Lordship. Within 10 days time, Lordship.
you know, let us Let us see on 20. You couldn't vote. No. Who is going to pay the compensation? The direction was paid for him. When was the direction that he is not a year? He voted?
We voted in 97 that
Oh, no. When it was found that he was no longer a year.
on 29/5/20, the final order is 6/6/2024. 24, I was declared as not a foreigner. Then I have given
A
representation.
valuable vote has gone. You pay compensation for that. No.
I have given representation also along with this order
And when did you submit the representation?
on 39/2024.
Then?
But no,
You have debarred him, valuable person from voting. Why compensation should not be paid? We're having it on 15 propriety. We can't give you 7 days, 4 days. 4 days. If you don't do it, pay compensation. I'm asking the chief electoral officer. No, ask the chief electoral officer to be present in the court. He has submitted the particular representation. Why on earth you have not? A valuable vote has gone. Then
Immediately after 15 days. On 15, I saw no real vote. So this is why I'm requesting.
okay, 18th. It's the matter on 18th. This is an application filed by the petitioner being aggrieved by the continuation of the petitioner's name as the the marking of the petitioner's name by the continuation of the remark D included against the petitioner's name in the electoral rolls, in spite of the fact that the petitioner have been declared not to be a foreigner by an order dated 6/6/2024 by the Learned Foreigners Tribunal. It is also seen that on 30/9/2024, a petitioner had duly submitted the representation to the district election officer along with the copy of the order passed or of the opinion rendered by the Foreigners Tribunal. The respondent authorities, however, did not remove the remark E, and thereby the petitioner lost out from voting in the recently held elections to the Assam Legislative Assembly. It is further seen that in spite of notice having been issued by this court on 25/3/2026, no steps in that regard have been taken till date. Considering the above, list this matter again on 18th of May 2026. It is observed that in the meantime, if the petitioner in the electoral roll the remark D remains against the name of the petitioner, this court would consider as to will show cause upon the chief electoral officer as to why compensation should not be, damages should not be imposed. Election Commission of India. What is this? Again to the other person, no affidavit has been received from the end of the respondent.
The pertains to non-payment of contractual bill. Though the PWD is a party, my lord, actually the works pertains to the health department. So they have executed it. Now, my lord, pursuant to requirement by the PW department, my lord, the proposal has been submitted to the final.
Amount is admitted.
Yes, see, my lord, that amount, my lord, yes. Exact amount has been sought for, my lord.
Yeah, it has been processed for payment to ensure compliance with the instructions and directions in content case number so and so. So the amount and currently the proposal for filing is with the finance department for conference to take it forward. Amount is submitted, 8,13,000, isn't it?
But we grant us some time.
Shortly, 15 minutes.
Okay, we do one thing. Let's have it on 8. We don't have 8.
Well, let it be, yes.
8 of June. No, you only require the financial sense in there. Because it's the content. Mr. B will go to learn. Because generally will spending council of the health and family welfare. Department. That the proposal have already been submitted for payment of an amount of 8,13,393 to the petition before the finance department for conference on 29/4/2026. It submits that once the conference is available from the finance department, the said amount will be. This board also takes note of that the Mr. Big Over is also the standing counsel of the finance department. Under such circumstances, he may instruct, he's requested to instruct the finance department for carrying out the necessary formalities for the financial sanction so that the petitioner could be disbursed the amount. Accordingly, list this matter on 15th of June 2026. In the meantime, the respondent shall ensure that the amount is disbursed. The communication which has been played by Mr. Legal is kept on recording. From bill, but
Or investment,
non-payment of bill of 2019, why is it pending so late?
2028, 2018, contract election we have supplied to the replacement sale. Out of which 24,13,000, 7,00,000
What payment?
and 17,29,27 yet to be paid.
You have got money
No, look, only 7 lakhs has been paid.
out of,
Out of 24,13,200.
were you not paying?
No, we have an affidavit, my lord. Lordship has disposed similar matter, my lord, regarding election, my lord.
Oh,
Petitioner will submit.
matter.
Yes.
It
Petition, fine. The Dilip Botra case, my lord.
remember the name. What did I, what order did I got?
WPC number 37309. 7309.
Of 2023.
23.
Initially, I didn't want to pass that order, well, but couldn't help it, taking into account that all these things are admitted by you.
District Commissioner.
Huh?
7309.
In partners of lordship direction dated 15/12/2025, the district commissioner had filed affidavit.
In
15/12/2025.
very clear cut admission of it. So he has filed
That
an
affidavit page 27.
he have admitted the amount.
Yes, that's after PNRD also filed affidavit. They have stated that they have forwarded the bill to the finance department for sanction of budget. Finance department returned back the file with the endorsement to verify the original bill. And also directed the secretary to verify and give a certificate of originality. I don't know, Lordship, whether thereafter, whether that certificate has been there for being given or not. I think some also, yes, that order.
So this is different.
Well, in this
This is
case,
different. Understand? Different. Even the other matter, this is a different.
well, in this case also,
Mr. Harris now.
yes.
Harris, you think the law, you. Anyway, this is the matter where the technical is saying that look here. This is the amount I have paid, and not only that, I have also sent all the documents to me. The commissioner PNR to say, no, no, we are not the suit. And because of this person, the person was not getting. Then I say, when somebody submission was said that the bills, you submit the duplicate bills and these duplicate bills will be verified, taking into account the technical was only admitted. It's not, the will verify, it cannot, and therefore, yeah, duplicate, certificate by year shall be considered eligible for the purpose of. But nothing in the present case of other matters are there. Entire matters to those matters pertaining to A to B was appealed. Remember these matters pertaining to where?
Nulberry.
Yes, Nolberg.
DBS.
They were giving those people, now, the contract without even calling for this.
Yes.
So you came up with this, that these are various documents that are like fixing the rates and all. How it was being.
My colleague was appeared in that manner. My colleague was appeared.
Remember that?
Yes, yes.
So that will be connected with this, not business.
I have submitted this because, my lord, in this matter also, my lord, we have not received the original bills from district commissioner. That is why, yes, my lord, in this matter also. That is why I have submitted.
Hey, but the district commissioner may appear on
We have admitted
have appeared on behalf of the PN. Yes, take another order, long order for them. Just money to.
Thereafter, we have filed affidavit.
So thereupon you file an affidavit.
Yes.
Where it fixes the things to do with the PN.
Prior to that, the one order was passed last month, total 23.
Check within the instruction, let us see. It is being filed under PN code. So they duly mention it at 17 lakhs.
The order will be para 7. Paragraph 4 has been.
Okay.
Yes. What do you think? But here we have to ask the issue, why he is not feeling. Are you looking to his affidavit? Huh? Because there has been continuously letters being written by the government in the PNRD, and the section 34567, asking you to provide the validity of submit certificate regarding the validity of the bail and voucher for almost substitute to the client. Why has to be over? No such original bill and voucher to be certified has been submitted to the office of the commissioner by the because the district commissioner called today and you are reading the affidavit for the first time along, you know. Take it if it's no, who got no contract TV, therefore we don't have good methods. We not able to do that. We get it because you tell him this. Once you tell him this, then he will give you an instruction. Then he will be forwarding or he has not. Then I'll pass the consequential order. It will be effective for everybody. It will be the where is Mr. Big Boy? I don't know, why have you approached this court so late?
My lord, fully that was, nothing has been done during this period, my lord. They are waiting, my lord.
No, maybe,
We are
but,
waiting for the.
no, maybe you have been shown to be technically disqualified on 16/2,
My lord.
and you knew about it on 17.
No, by this time, we are waiting for their reply. They did not give me reply. Because
Maybe, but you also know how the tender process moves.
my lord. But because of the, my lord, the election, my lord, could have,
Election came on 15/3.
my lord.
So this was on 17/2. You submitted your representation.
Fine.
And in the matters of tender matters, you do it as urgently as possible, don't you?
But then, my lord, they will give my reply to my.
Because with the reply, you will be satisfied.
So they did not.
They are coming with the instruction and maybe after something. I will place the one. They are coming up.
Take some time. Yes, item 24. Where is Mr. N?
Compared with them, my lord, they are very kind, my lord. Some,
What is to verify?
whether my lord, original software is available with them or.
Is not the question out there. The question is, they have asked you the documents in 2024. We are in 2026. You take care of that. PNRD has been writing letters so many times. Like the PP doctor, the learned counsel appearing on behalf of the petitioner. The MCTI appears as doctor appears on behalf of the PNRD. The petitioner herein is agreed that the inaction on the part of the respondent authority in making payment of an amount of rupees 17,13,200 shall be duty by the respondent or this one also takes note of that an affidavit has been filed by the respondent number 3 and 4, wherein the said amount has been duly estimated. Apart from that, it is also seen from the affidavit filed on behalf of the respondent number 1 that the amount have been exposed, the amount of rupees 17,13,200 have been told to be admitted. However, when the matter of financial proposal was sent to the finance department for consideration, the finance department tried a communication dated 3/9/2024 informed the commissionerate of the PNRD that requesting to submit the genuine and duly verified bills and vouchers. Under such circumstances, the commissionerate of PNRD had written various letters to the respondent number 3 and 4, as would be seen from the affidavit filed by the respondent number 1, for providing the certificate regarding validity of the bills and vouchers for onward submission to the finance department. It further appears from the affidavit filed by the respondent number 1 that it is on an the inaction on the part of the respondent number 3 and 4 that the further processing of the bills of the petition have been stalled. Considering the above, is this matter again on 8th of June 2026. The respondent, the Deputy Commissioner, District Commissioner Gauhati is directed to apprise the score as to whether in continuation of the various communication referred to in the affidavit filed by the respondent number 1, the certificate regarding validity of the bills and vouchers have been submitted to the Commissioner PNR for onward submission to the finance.
Meaning for item number 26. 1430 of 20. The petitioners are the registered association of rickshaw drivers. Allowed, and they are challenging an order that is passed by the Gauhati Municipal Corporation, page 42. We are the retrofitted electric motor rickshaw. See the input order now. Page 54, my lord, you file an RTL before the Commissioner of Police, get the information about it.
Mr. Bola, tell me, where is your offer? As regards safety with the motor vehicle, why they are not doing? Or are you saying that these are not for?
Why did it have been 126? Because the vehicle runs more than 10 kilometers per hour. They're under rule 126, they have to get a certificate. That process has to be done. That testing has to be done, then get a certificate.
Either
By the
motor vehicle.
manufacturer.
Okay, final. What do you use? E-rickshaw. Why is it? Why is type approval? Because the 126, the manufacturer take type approval, and thereafter it will answer, and if there is any violation of running any vehicle without type approval, then it is a violation under the Motor Vehicles Act to Transport Department. The petitioners, my lord, they are not e-rickshaws. They are retrofitted motorized rickshaws. It's a different category which there is no type of violence. Yeah. Within the ambit of the motor vehicle, it doesn't fall under the category of motor vehicle. There's
The root side is the the definition
section 2A, my lord.
first CB, e-rickshaw. E-rickshaw is different and you find out battery operated vehicle under which we are there. We are not e-rickshaw. Operated vehicle. How is the definition saying about 126 about e-rickshaw? But the input order says for the safety reason. The Commissioner of Police at page 55 on our RTI has given the information at page 55 on our RTI Your lordship will find. Commissioner of Police, number of motorized for the accident, the name of the accident of motor vehicle, name of the person suffered death, date of place of the accident. To an article that was the Commissioner of Police chief. And my lord, regarding the technical feasibility of the motor rickshaw, page 59, last part one parent. That was by some Amaranthu State from IIT Gauhati. Last part one parent. He is the designer of this big power electric. I don't think you want to, but there's nothing about the input order, but at page 81, paragraph 6. They have discussed 126.
But I understand everything. But why the James? What is the power of GMC for enforcement of the motor vehicle?
And these rickshaws were retrofitted by the motor, converting retrofitted. For rickshaws, my lord, that is pedal rickshaws, we have an act. But what had happened, my lord, these,
You have an act.
there is an act.
What act?
It's a rickshaw fitted, this is an act, my lord, for the rickshaw, to governing all this.
Where is the act? Huh?
Lord, will be now 454, 458, my lord. $458. Yes. What a municipal corporation within bracket licensing of rickshaws and rickshaw pullers by law 1976. But what they have done is that these old rickshaws were now converted. Retrofitted motors have been fitted, make it electric. That's why in the input order itself, in the last paragraph, we have only had to remove that. So will run, but with motor it will not.
But how are you applying this law to these vehicles?
But they have, in their own, they have fitted that motor, making converting the old rickshaw into a motorized rickshaw. That's why in the last paragraph of the input order,
No, can you come to entry of the rule bylaws? No person shall keep for hire or ply for hire a card drawn by any man without a license granted by the commission or otherwise then in accordance with the terms and conditions of the license. One. No person shall drive a car plying for hire unless owner or flyer holds a license to in a, it and except in accordance with the terms of the license.
Yeah.
No car shall be allowed to move within the city without rubber covering on the wheels.
So we issue a license for rickshaw pullers. We have to pay a small amount of money and then we issue license. And now these old rickshaws, pedal rickshaws, now they have started
No. Issuing a license is for the purpose of what?
rickshaws.
For what? For collection of tax.
Yes.
For levy.
Maybe. And as well, they
For
will get a
levy
license.
upon the rickshaws. Now, what has happened in view of this, to you, it will come within the ambit of a motor vehicle.
What had happened with Mother? They fitted the retrofitted, they increased their speed beyond 10 kilometers per hour. Then it comes under bit of control. They have to take, the vehicle has been totally changed.
So therefore, if it comes under 126,
120. Then moment that,
once it comes under 126, where is your power there?
because that's why my lord, it said they have to take a license from the GMC. That's why in the last paragraph of the order,
No, if it is the vehicle, it comes under the motor vehicle. Then they have to take a license from the transport department.
that from the government.
So
They have to-
transport department can enforce it.
Department
How do you ban
because the
it?
safety and security of the people, my lord, moment it goes into such a fast way, my lord, that accident.
Let the police do it.
That's it. That's why, my lord, we want that
I understand everything, but who need the power? Why should you?
power will be safety and security of the people. That's it.
But safety, then tomorrow you may say that no cars should also be running out there
My lord.
because there will be an accident.
Yeah, but because they take out license from the GMC.
Does
They have to
the,
change
does
it.
the, does the GMC have the power as regards rash and negligent driving? My question is,
No.
no, same apply. And for the police to look into it, it is for them to look into it. Not by anybody else. It is not a point, it's a power we get to by. And what is the other matter for?
Same.
Lordship, the reply, if I get this on my head, page 40 and 41, page 40 and. Yes.
We put the name as tricycle, it doesn't become the tricycle. Yes, transport department, why are you not taking action?
One thing type approved by the center. There's a portal on which every manufacturer is supposed to apply after rigorous testing of all the mechanisms. Prototype. Yes, madam. The prototype is then tested and then it is approved. And then once that happens, on the DTO level, madam, the option is there and then we register it. Madam, the transport department enforces any violation of any motor vehicles, if there are any violation of any caused by any motor vehicle. Madam, they come to the affidavit, madam. The retrofitted vehicle, vans, they are not under the category of any motor vehicle. They are neither e-rickshaws under 2A, they are battery operated, but they are not under.
What about 2?
Motor vehicle rules 2U, if I may read. Battery operated vehicle means a vehicle adopted for such use upon roads and powered exclusively by electric motor whose traction and energy is supplied exclusively by traction battery installed in the vehicle. The problem is that, first of all, my lord, there is no type of rule. There is
Actually, different. In a prototype, here then in fact it cannot allow them to do that. The thing is like this, which I understand. All vehicles, motor vehicles, motorcycles, all these things, there are also quadricycles with them. So these vehicles have to be first, there has to be certain tests. Once these tests are being approved, then in that case, these tests approved, then the ministry out there would approve it. And then this approval will go to all BPOs, RTOs all over the country. On the basis of that, they can then register. You cannot register otherwise. That's the law. That I know. My question is, yeah, they come under 2U by making this a retrospective law. Now, once they do it, but they no approval, no license taken by them. How will they run? Enforcing has to be made by you.
It will be done by the police level.
At the state, but police, you take the help of the police. Now tomorrow, tell me, a person who doesn't have a license, if he drives it out there, he will be violating the provisions of the motor vehicle act. The police can very well take action against that. But at the end of the day, who is going to give the license?
You better be doing.
The fine will go to where? Motor vehicle department in that head of account. Isn't it? So this is how it is there. Tomorrow, a parking happens. Parking violation happens. It is you who has been doing it.
No, the parking violation might not be right, my lord. It will be the enforcement of the act, but might not the action is then taken by the police.
Police takes it.
Yes, my lord.
Because you don't have that infrastructure for the enforcement.
Yes.
So the police takes it. But the money will be paid to you.
No, my lord, there is a centralized system. It's not directly that.
Understood? It is centralized. Will go to that fund.
Yes.
You don't pay it, or overspeeding, you don't pay it to the police.
My lord, it is the portal.
It's a portal, and that portal is under the Department of Parivahan.
Particle.
As I understand. So therefore, a person who is flying a vehicle out there, it is for the police to look into. But what is GMC going to do? Can the GMC enforce Rule 126? My question is that. No, they cannot do that. The police will. Yes, the police look that they are running that anything against them. They cannot do that. That once it comes under the we say it will be a case where it will be retrofitted. And it will be a case where it becomes a battery operated vehicle. Once it is a battery operated vehicle, the GMC may not. At the same time, it cannot also run in view of
Another, if I may correlate it, another 2U battery operated vehicle, this would be then has to be read with section 2A of the Motor Vehicles Act, which says that those are the three-wheel e-rickshaws. So my lord, my submission is, if I may read number 2A. Read my lord. Save as otherwise provided in the proviso to subsection 1 of section 7 and subsection 10 of section 9. My lord, 2A. Section 2A of the Motor Vehicles Act. 2A. 2A.
the Motor Vehicles Act doesn't have to wait.
My lord, may see.
What is that?
It may be amended by the Motor Vehicles Act, my lord. It has been inserted in 2015. My lord,
Not to wait, either.
my lord,
Save is otherwise provided in the proviso to subsection 1 of 7 and so on. So the provisions of this act shall apply to start any eviction. For the purpose of this section, regard or increase special purpose about vehicle of power not exceeding 4,000 watt for carrying goods or passenger for hire. So you will be paid.
if I may submit my lord, section rule 2U will apply to all vehicles which are like battery operated. Might also be a battery operated LMP. My lord, but the petitioners might not, they are stating that there are 2U battery operated e-rickshaw. They are trying to come under this section. But since they are not a e-rickshaw, there is a discrepancy there.
No, but who A is in respect to license?
But no,
Who A is otherwise provided the proviso to subsection 1 of section 1. And so the provisions of the act shall apply to what depart in.
And 2A,
But they have not included battery operated vehicle.
well, 2A, 2 my lord, if I say 2A subsection 2 my lord. For the purpose of this section, e-cart or e-rickshaw means a special purpose battery operated vehicle of power not exceeding 4,000 watts, having 3 wheels for carrying goods or passengers, as the case may be for hire or reward, manufactured, constructed or adopted, equipped and maintained in accordance with such specifications as may be prescribed in. So why not under the specifications, then they will require to be fulfilled. Madam. Since they are retrofitted, they do not fall under this section. Madam. We have taken that stand in our academic issue.
No, but the fact remains out there. The motor vehicle rules mainly define e-rickshaw and e-cart in 2CB and 2CC.
Okay. Cards and vehicles.
So this is being defined. But if that be so, are you saying that battery operated vehicle could not come within the ambit of motor vehicle?
My lord, do you come under motor vehicle, my lord? I'm saying my submission, my lord, that the petitioner's vehicles are neither e-rickshaws or e-carts, my lord. Which comes
No
under
quarrel with that, but then also, when the legislature or the executive who makes this rule, makes it very clear. In the definition clause, e-cart, e-rickshaw, as well as battery operated, meaning thereby, the authorities have really taken into account and found out that these are different space. So therefore, e-cart have been put differently, e-rickshaw have been put differently. In section A, capital A, of the motor vehicles have only mentioned about e-cart and e-rickshaw. So therefore, should the battery operated vehicle be outside?
Well, my submission is that my
I see battery operated vehicle means the vehicle adapted for use and powered exclusively by a electric motor whose traction energy is supplied by exclusively by traction vehicle installed in the vehicle. Provided that
that
we
is
have battery. We are not concerned with a vehicle is equipped with the electric motor having 30-minute power less than 0.2. Maximum speed of the vehicle is less than 25 kilometers. Vehicle is fitted with suitable brakes or retro reflective devices that are for all of these. Unladen weight so and so is not more than enough. In case of pedal assisted vehicle, equipped with the auxiliary so and so because in addition to the above, the particular power of the vehicle, motor is less than so and so. Whose power is progressively reduced and finally cut off as per so and so. So,
well, these will apply the proviso, my lord, for two-wheel vehicle, my lord.
we are not concerned with
Well, the main part, my lord, I mean, the cross means the vehicle adopted to use upon road and powered exclusively by electric motor. But the problem here is perhaps that the petitioners e-rickshaws are retrofitted and can be pedal and both used with a motor.
So you mean to say, if it can be pedal, if it is a two-wheeler,
Right. But since
if it is a two-wheeler, then only a pedal can be permissible.
my lord, that is
And to come within the battery operated vehicle.
yes, that is the
That is
the
what
stand,
you're trying to.
that is the stand we have taken in the academic as well.
But then also, at the end of the day, when it is a motorized vehicle, may not be prototype, nothing has been done. But isn't it your responsibility to look into that? How does the GMC will come into this thing? And if GMC says that we are applying 126, then it is not a motor vehicle by its value. Then the 126 also doesn't apply.
Or which is the one.
But if 126 does not apply, where is the power of them? To ban it. What they have done is banning it.
Second part of the moving part.
Remove the motor to the disability of the banning with appropriate action which we initiated as per Act of bylaw. What action you can take? The bylaws do not say if you have a motor, you are not going to allow. Does the bylaw say? You may say that you may cancel your license. You may just say that, okay, we are not going to do your license. You may do that. But order cannot be done. You may say, okay, now as you have the motor, so therefore we are not, it is outside our, we are not going to done. But not this order. And your affidavit is wrong, saying, because they say that the motor, not a motor vehicle. If it is not a motor vehicle, then 126 not apply. We are not the enforcing agent. In fact, it is for them to look into that you are running a motor vehicle. You are running a motor vehicle in the day of so and so without a proof of life, and therefore it violates the rules. And that, and therefore they should ban it. If they pass the order, it is look into it. Or the policeman should take it, but you are nobody. But we see at best a license or not.
Perhaps this will be a little bit of a area, my lord, if they are not motor vehicle.
We have it on another day. In the meantime, we take a call. We take a call to withdrawing it and then they think that we are not going to judge the license because the license is only allowed without
Genuine question.
because our license is only for. Then we are for purpose itself. Then let them do whatever they do because otherwise what they are doing is wrong. But you are not the authority for to enforce one thing. 1976 is for license. It is for license. You don't need a license. Or you need a license. Let them come up. Let us see Mr. Peter will choose me again. Okay. And what is the other matter for? Same time. Okay, let us third Mr. If your like without the battery, then they have it with the light. But if it is without the battery, with the battery, then they cancel the license.
No, we not already, while these orders have been issued, during the operation of the interim orders, what they have done, the police, by using the police, the DMC officials seized the battery, we have made it, find a high, that also, that the batteries which have been seized, they should be removed. DMC has.
What are you with the battery? Then they sell it.
Not again installing.
No, you cannot install it. You cancel their license. Art Mr. P.K. Chaudhary, the learned senior counsel, hearing in application number. Application number 1430 of the 2023, assisted by so and so. And Mr. Back to 2023. The present both the petitions are raises similar issues. Because from the reports, it is seen that the petition being the petition number 1430 of the 2023 have been filed challenging an order issued by the Commissioner GMC dated 28/12/2022, whereby on account whereby The Commissioner GMC had directed all concerned owners of motorized rickshaws to remove the motor within 7 days from the issue of the order, failing which appropriate action would be initiated as per the Act of the bylaws. It is the case of the petitioner that the GMC has no authority to pass such orders, inasmuch as the rickshaws wherein which are retrofitted with electric motors would come within the ambit of a motor vehicle, would come within the ambit of Rule 2U of the Central Motor Vehicle Rules 1989. What you are? What is that? You are?
$59. Last word, one second. Why? That is the fee for the bicycle. The electric machine to work, right? That's your deep behind.
What is
Low
it?
floating, there is low floating, deep behind. We are not e-rickshaw.
Would you come under 2U, battery operated vehicle? That is what I'm saying. I'm not saying about 2CB or 2CC. I'm saying 2U. U of the Central Motor Vehicle Act 1989. It is the specific case of the petitioner in WPC number 1430 of 2023 that the vehicles of the petitioner of the members of the petitioner association are deep behind tricycle rickshaws. The record reveals that the GMC has filed an affidavit wherein the stand so taken is that the plying of these rickshaws retrofitted with electric motor is contrary to, is in violation to Rule 126 of the Central Motor Vehicle Rules 1989. And therefore, on account of enforcing Rule 126 of the rules of 1989, and also and for the safety of the people, the impugn order dated 28/12/2022 was passed, was issued, was made. However, from the stand so taken by the Transport Department, it is seen that these rickshaws retrofitted with electric motor would not come within the ambit of motor vehicle, in as much as it does not fit the definition of e-rickshaw as defined in Rule 2 small cb of the rules of 1989, or Rule 2 or battery operated vehicle as defined in 2U of the same rules of 1989. This court also, during the course of the hearing, inquired with Mr. Espora, the learned standing counsel of the GMC, as to how the GMC would have the power to grant a license if it is a motor vehicle, in as much as it is the stand of the GMC that steps that the impugn order dated 28/12/2022 was passed taking into consideration Rule 126 of the Rules of 1989. It may not be out of place also to take note of that the power to grant license under the Gauhati Municipal Corporation licensing of rickshaw and rickshaw pullers close bylaws 1976 springs from it's a power drawn from section 167 of the GMC Act 1971, which empowers the GMC to levy tax on certain vehicles, boats, and animals. It is on the basis of such power the rules of bylaws of 1976 have been made. It is very pertinent, however, to mention that power to tax is different from the power to regulate. Under such circumstances, this court inquired with Mr. Espora, the learned counsel, learned standing counsel, as to how the impugn order could have been passed by the GMC authorities taking into consideration section 167 of the GMC Act 1971, and more particularly taking into and further the very stand of the transport department that the vehicle, the rickshaws with retrofitted electric motors do not come within the ambit of a motor vehicle as defined again the Motor Vehicles Act 1988. List this matter again on 15th of June 2026. Power to regulate and power to take certain.
Interim order.
What interim order?
They were, my interim order was there.
Interim order for what? You are running.
They were trying to take away our battery.
Battery, they,
One for
you do one thing. You don't take the battery, but you can cancel the light.
One of the things.
No, interim order, how can there be interim order that? No.
Page 41, you must be looking. They were,
Safety of people is more.
76 was to be amended and this.
Not be
rickshaws were
applicable
to
to
be
Deepahan, Pitabilia. No, Deepahan and all. First of all, did you comply as per the prototype? You are, if you don't fall within motor vehicle, then you cannot, there cannot be a running of any vehicle.
Just look into one page
Fact, if you-
41. Page 41, they were amending 76 to include the motorized tricycle rickshaws, but they have not incorporated that one. You're page 41. You're also made by repetition. They were asked to incorporate that in the 76 Act. You're also page 41. They were asked to amend this 76 bylaws by incorporating the special legislation of motorized tricycle rickshaws.
In this regard, views of the transport department may kindly be taken into consideration.
Hello.
Yeah, this is what that says.
So, there is an interim order where they will pull our batteries out. Because we buy these deep bounds, what we apply,
What is that pull off?
they are taking away our batteries because the interim order is continuing for the date of finding of the repetition.
Interim order, this type of interim orders cannot go on. We say that, okay, not to pull away your vehicle, but you cancel the license.
Well, your option.
Cancel the license.
But that may not be incorporated the cancel the license.
So you ask for that interim order, I will only pass that. Otherwise, keeping silent is kiss. Mr. Bhuya, they the poor rich and all. The question is, if you want to have the vehicle, you see, I have seen this. I've done a few matters of this type, so I know it. I've seen it. If you bring it a motorized vehicle, in fact, it is a, in my opinion, there must have been something lapse on the part of in the 1989 rules not to bring you within the motor vehicles. It should have been brought within you for the motor vehicle because it is motorized. Therefore, it is motorized, so it has to be brought within the ambit. Now, if you don't bring it, and in fact, they never thought this ingenious thing which you are going to do. So they never thought that. Now, you having been done this. Now the question is, if it is not regulated, if they can't regulate, then it will lead to a chaos. Where's the rule of law? In fact, in my opinion, that they have no business out there. It is they should think about it, but they cannot do it because he's only the Department of Transport of Gauhati, Assam. It has to be done by the union. The union has to take part. So you have to make the Department of Parivahan a party. You have not made them. Think about it. But I'm not going to. Silence is peace. What is there? The judge may have forgotten.
Yeah, they got it. First order in there, but not to take coercive action.
Obviously, how can there be? Because the moment you see, on one hand, you are saying the GMC has no business. You are saying if GMC has no business, the GMC can remove the license.
No, that is, they
No,
can,
tell me.
no, they can, or subsidiary, they have to.
Now, without the license, the 76 rules comes into play.
Let them pass that order of their own. But till then, Malad, if they have not passed, this input order is bad.
Let them pass. We pass.
Malad, but that input order, what is there, Malad? Till then, Malad, no question action. Otherwise, tomorrow they will start putting up order.
Don't pull them. Don't pull. Don't pull up. Do what I have indicated. Don't pull. I am giving you time not for the purpose of doing all these things. I am giving you time to think about it, what I am saying. Tell your GMC commissioner not to do. And they have no business out there to do it. Anyway, next one. Service is complete terms of login order. So what is the case? Yes, Mr. Council. The suspending of BTC of jury after where the petitioner was detained by the impugn order, the by the understood. So. What should we do? What is your stand?
Lordship, the reparation has become infructuous, Lordship, because the case has become infructuous, Lordship, because they have assailed the order dated 13 to 23, Lordship, whereby the VCDC was prosecuted. Thereafter, Lordship, when the new government of BTC came in the month of October 2025, subsequently a new notification was passed in the month of February of this year, Lordship, where a new committee was constituted. I have the
Mr. N.R. Sharma, the learned standing counsel of the BTC subjects that the petition has already become infructuous in view of the fact that the challenge to the notification dated 13/2/2023 by which what is it? VCDC of Dala Bila was constituted, which is impugned in the instant proceedings, no longer remains, taking into account that by the notification dated 26th of February 2026, a new VCDC of Dala Bila under number 1 Orvot Thora SP BTC constituency have been notified. The said notification dated 26/2/2026 was placed before this court, which is kept on record and marked with the letter X. Taking into account the above, nothing further remains in the writ petition for which the writ petition stands closed as it has become infructuous.
Can they come to ungiven?
What are you challenging? Huh?
Okay. Order.
08.
11/11/2022. Asking WPC 5633 of 2020. But the motion also been private at page 115.
Yeah. What is it order?
Because this director, even minister, also include. There
Is the direction here? I've heard the learned counsel for the party that deal with the mediation case of the judge. Will specific judge give it to- Okay, pursuant to that order passed.
Partial to the order has the first at page 118. Now, 119. Then, page 119.
Yes. What is wrong?
Name of the lease. Site number, date of execution of lease deed, along with time period, date of execution of renewal of lease deed, same term. Date of execution of renewal of lease deed, third terms. Motion can be. Date, 01/10/2019. In the affidavit filed with the respondent, they have not annexed that lease deed of 1/10/2019. And
No, no, what is wrong? You are challenging the speaking order.
Yes.
Why?
Because he knew the respondent number 4 was the leasing,
Was that?
was the tenant
Oh,
of the. This is petitioner's father. They-
so how can this court decide all these things? Go before the civil court. The civil court, the matter is pending. The matter was pending. It is in pursuance to the directions passed by them. This has happened. Then what the civil court directed, the appellate court directed, that kindly he will hear both the sides and pass an order. Now, pursuant thereto, what has happened that there was a lease deed given to the petitioner. Who is the petitioner in the earlier petition? You. It was given to you. Then you therefore, and it was given to you. And thereupon, later on, the executive officer came over and said that no, we issue a notice. Against the notice, you filed the petition before this court. I did not interfere with the notice, and rather I say that the issuance of the lease deed not so proper, taking into account there was a specific direction none of the parties could produce the copy of the order. So therefore, I directed to look into and decide it. Now, in pursuance of thereto, they have decided something. Now, rightly or wrongly, they have decided. So if there is anything out there, you have to file a suit. Why should this court look into it? Who was the owner? When was there? Whether you are a tenant or not? Not. This is not a question of it. Earlier, the exercise of jurisdiction was only in respect to a notice, whether a notice should have been issued when a lease deed has already been issued. Why? That was the question. Here, why? How am I going to look into this aspect? That's your submission. Please.
Last. Actually, the date of execution is 1/10/19. There is no such date. 1/10/2009. And no such date.
So,
And
no,
Yeah.
whether there is a deed or not, how do you think that why should this court entertain under 226? Go before the civil court. There's no challenge this order
we are
before the
before the
civil court.
civil court has passed the degree in our favor. The appellate court has.
Now, has the civil court held? Where is the civil court's decree? Let's see. And what is this? And page 100C? 100C. What is that document? 100C. Annex 14.
This is the agreement with the.
This is the first day of March 2019. That is what They are
March
mentioning no.
2019. And this deed, your lordship has interfered. Your order is here.
Have I interfered with the lease deed?
Yes,
No,
it's yours.
I have not interfered with the lease deed. Why will I interfere with the lease deed?
Yes, because just your lordship see the judgment.
I've seen it.
Last, there is 117 page.
Okay, taking into account that there was no compliance with the judgment and decree, the lease deed dated 1/3/2019 is interfered with. So therefore, Mr. Counsel, it will be here. Kindly come to 1119, 119. Kindly see, first party, there was a lease, 31/10/2008. Was there a lease deed?
But you are 2008.
Was there a lease deed?
It is in their favor.
Understood, there was a lease deed.
Yes.
We are this, we are,
We have
this,
challenged all these things before the trial.
what has happened? What is the trial court say?
Trial court is decreed in our favor.
Where?
It is page 49. And the order is page 56.
Oh, no, no, kindly come to page 69. Judgment passed by the trial court was interfered with by the appellate court. Kindly come to paragraph 22.
Then it is sent back to the authority.
Authority. Now the authority has decided this.
Decided, but
So there is no declaration by any court that this particular deed is bad.
Yeah.
Then,
this particular deed, that is 1/10/2019.
no, no, not on 110. What about 31/10/2008?
110, yes. In this case, what happened, Your Lordship? There is a deed with us and the petitioners for others. It was executed in first day of April 1995. Entire plot of land, entire plot of the shop,
For the entire
shop, that is the best.
Ah.
Shop is measuring 21x50. Now they have, this is executed in 1995 for a period of 20 years. And this exists at that time, they have executed this.
kindly come to page 184. That is their document. This is the renewal lease. This is a registered document.
Nineteen 1995 deed is there. Without modification or cancellation of the deed, how they have executed such type of deed?
So therefore, don't you think that there is a requirement that in fact, I'm a bit surprised when the appellate court passed the order that sending both the parties, it is as if the judge acted similar to what the writ court does. Don't you think that? When the matter was as regard a challenge to a particular document or whatever may be the lease, the court should have passed some orders. The court in fact relegated the power or leads power to the authority. We directing it's a different thing, taking into account that the authority normally decides. We don't look into it in 226 factual aspects. But it wasn't the first appellate court, it's civil court,
Yes.
was exercising that power?
No.
Huh?
Master,
Can you see page number 66? And page number 66, point number 16. Page 66, point number 16.
Yeah, couldn't be.
In support of disputed issue pertaining to the question as to whether the appellant was a tenant under the respondent or not, the plaintiff as PW1 produced the agreement dated 4/10/89, Exhibit 1, executed in between the parties. The detail of the terms and condition of the lease is mentioned in the document, but the question remains to be answered is that whether that agreement is admissible in law or not. Firstly, as per clause 9 of the said agreement, the tenancy would last till 31st/12/1995, section 17, subsection D of the.
LEC, no, madam. LEC page 40. What was your suit for? A declaration was sought for
yes,
by you. You were the person who had the plaintiff. That the order dated so and so passed by the so and so granting him lease of the property mentioned in cancelling an year is null and void. So the civil court ought to have decided that. For cancellation of a lease deed so and so, which was granted mentioned in a thread below by the order dated 2797. So these deeds are there which you have challenged it. Now, how can a cancellation of a lease deed, which is a subject matter, be decided by the Dibrugarh municipality?
yes.
So Dibrugarh municipality could not have decided because the lease deed has to be declared by the court. The cancellation is an instrument which has to be done. No, therefore, what happened in this case is you should have filed an appeal. Now take into account the explanation 4 or explanation 5, as well as explanation 5 to section 11. It will be shown that these are the relief which you have sought for, and these reliefs having been not answered, and there is no appeal there against filed. Your case is that you are now stopped from constructive res judicata. And if this is a constructive res judicata applied, then what is wrong with this order? That case, I think it's a case for dismissal, don't you think? Huh? Be dismissed.
Your lordship, the deed which they have executed. They have executed, that they cannot execute that.
So under such circumstances, what is your relief we should seek for? You should seek for that there is no existence of any relief, that this order is bad, taking into account about certain documents.
At this time, only my prayer is take the notice of these things by the municipal authority.
And
Remand back into the municipal authority again,
for,
reconsideration, because there is no. date
first of all,
for that.
why on earth should I exercise that? There is a deed. Forget about 110. I have set aside. There's no 110. 1-3 it was there. 1-3 I have set aside.
Your lordship has already
Understood, it
accepted.
is set aside. But the fact remains there was a deed prior to that.
And the second thing is that they have not considered certain documents that I have submitted.
Kindly see, this term was valid till 2013. 31/10/2008. Then you see these deeds, more particularly, kindly 24/6/97. This is a deed you sought for cancellation by a suit. Court rejected it.
Appellate would be-
That is why appeal is a continuation of a suit. So the appellate court has rejected it. Once the appellate court has rejected it, this deed comes into existence. And these other deeds are fallouts of this deed. Why should I remand? Better off going before the civil
Because
court.
Your lordship has interfered with it 1-3-9.
Yes, I've interfered, but that cannot be the reason why they are giving it. Kindly see. Kindly see here, see the reason. That in the year 1989. In the year 1910, these deed was executed by Sonkolan in receipt with Dibrugad municipality to the both the sites so and so and that. That in the year 1989, shops of both the sites were gutted in fire. The second part is Sonkolan so and so obtained construction permission of the Iman with a mainline road covering the so and so under occupation of Dr. and Sonkolan for the authorities so and so and so and so. And both had reconstructed the building, shop building thereupon, and their individual site premises at their own cost. That both the parties have executed lease deeds with the Dibrugarh municipality against their respective site premises, and they have been paying the site rent as per the municipal taxes. Now, one was of 97. This deed you have challenged it. Now, you see, your deed, which you have entered, Pawan Kumar Bauri had entered on 2/8/1976, the first deed.
7.
Then, at that point of time, that Dr. Brothers came in, I think, in existence on 24/6/97. Obviously, there is some deed. Otherwise, you would not have filed a suit for cancellation.
Actually, the suit has been filed to declare the 26/5/97 order, because at that point of time, I do not know whether any agreement is exist or not.
You have asked
The lease deed-
no, kindly see the relief in the prayer. For cancellation of the lease deed granted to the
Yes,
defendant
that
on the
order
year on
dated such and
26/5/97. There's a lease
They,
deed.
they try to cancel my deed.
Ah,
That's why cancellation of the lease deed granted to the defendant in respect to the property mentioned in the schedule below, by order 1997. This is no order only. At that time, I have no knowledge about the lease deed of these two lease deed. 2008 lease deed also.
now, however, 2008 lease deed, but you categorically say that about the order that being highly
This is
agreed by the
97.
council prepared an appeal before the deputy commissioner against the sale order, details so and so they executed. Kindly see the relief sought for at page 40. For cancellation of the lease granted to the defendant in respect of the property mentioned in the schedule below.
Right?
Order dated so and so.
Only we know the order.
Then, so therefore, the lease granted so and so.
And the actual fact is that actual fact that was reflected in this order. They have not considered certain documents that I have produced before the authority.
So the defendant, he is in possession of,
He is part,
he's in possession.
he is position, but he has entered into agreement with me. I have subleased to her.
Your Lordship, at any point of time, they have not produced any agreement between the respondent and the original petitioner. That the respondent number 4 is a tenant under them. And as per even the terms of the agreement which they have produced, they cannot sublet the land to anyone without due permission of the municipal authority. And they have not used any permission also.
Yes, 235. This is the agreement between the father of the petition
That is
with the response number 225. That has not been done.
the document has not been produced before the trial court hearing, Your Lordship, for perusal. The trial court of the claimant.
So you don't have a lease after 85? No lease deed. You don't have a lease deed after 85,
95.
after 95. And this lease was given for in perpetuity,
Still I need what?
huh? For 20 years.
Your Lordship, since nineteen
So
twenty,
it has been over in 2015.
For the base litigation is continuing.
Your Lordship, the so-called document which we are producing before Your Lordship,
Okay, let's stop that. Interference by the trial court was 12,697. First, they have executed, then they have sent me. But prior to that, they should have sent.
Must be that is the case of before a civil court.
So let them to consider my case.
The fact remains that the respondent number 3, wait, you are respondent number 3.
four, Your Lordship, four.
The respondent number 3 is in possession. The fact that there are one amongst the 3, one I have set aside, definitely. So there is the requirement of entering into a fresh scheme, and that is what the order is. So therefore, there are already these deeds which are there. These deeds have not been set aside by a competent court of jurisdiction. There is no finding of fact right there by the learned trial court or by the learned trial court that proceedings where you have initiated. There's no finding of fact right there that you are your tenant. These are questions which can be only treated by the civil court.
Now, what would be my option?
Taking declaration that this is bad. But I do one thing, I let them dismiss it. And I give you the liberty. There is the better option. That's the only option left. Because what happened, main problem is you have agreed to the order passed by the learned first appellate.
Yes.
First appellate court, what did it? They said, okay, let the Dibuga municipality we decide by hearing to the. Now, there was a specific direction to hear the court of party. In fact, you should have challenged it because you have asked for certain declaration, certain consequential relief from the basis of their declaration. That gives you a tenant. A tenant could, under no circumstances, could have become this. See your plea. You were the sublessee.
Yes, I have submitted.
You have let out that some a part of the premise.
Yes, some part of it.
So therefore, that was decided by the court. The court did not decide. The court, on the other hand, remanded the matter for deciding of that order by the authority concerned. Then also you don't have a challenge to the order of 9-6. 9-6 order still has remained 9-5 2097 order still remains. What they did, they have entered into an agreement with them without there being with you, no?
Yeah.
With them. The 1-3. 2019, an agreement was entered into with them. They were the petitioners. in the earlier round?
No.
In the, we are the appellant in the appeal case, Your Lordship. Title appeal.
Earlier round, yes, they are the petitioner. Because
were
they have
petitioners
challenged some
here.
of
They were the petitioners here. So therefore, when they were the petitioners out here, they challenged the action on the part of the respondents. Then look here, that why are you issuing a notice to me after having entered into an agreement? Then I certified that agreement and said that we couldn't have executed this agreement without first giving a hearing to both the parties. Irrespective of that, they mention about that in the issue order and say that it is to be decided in this time. Now, can the Timuga municipality decide that he was a subtenant? Or can we include the Timuga municipality as the status of the civil court? Now, only problem lies in because of that civil court's order, the appellate order, you are put in a very precarious situation. Think about it. I mean, I can dispose it of, but think about it, what is to be done. Your main problem is that appellate court's order. You should have filed the second appeal.
revision. Revision petition I should have done.
That they have
Fact, we
withdrawn,
have-
they have withdrawn in fact.
In fact, they have filed up here, because I am not a consummated fact. They have withdrawn.
You should have
And
filed
then
the second.
they said that.
Because you
they have
asked
sold
for,
out.
you asked for civil adjudication, you remanded it to the, how is it possible? The judge acted as if he like a, I quote, what was the judge? Kindly see what the learned first appellate court did. Kindly come to page 52. What was the issue number 3? Whether the defendant number 3 is a tenant under the plaintiff, although disputed. Although the disputed site admittedly belongs to the defendant number 1. Okay. Now, the learned trial court held that defendant number 3 was a tenant of the plaintiff. The first appellate court held that in view of what has been discussed about, particularly the decision in here, the judgment and decree passed by the learned trial court cannot be sustained. Accordingly, the same is set aside. By modifying the judgment, I am passing that so and so. So, interfered with the order dated 26/5/97. Order was interfered with. But there is no decision as to who is the tenant. Now, can the Dibrugarh municipality decide that? Think about it.
Appellate court has done. Appellate court has given the order. We approve it.
Understood. But the question is, who can decide whether he's a tenant or not? Can the Dibrugarh municipality decide it? He can't give a judicial decision.
And maybe even some. Yeah, full person.
But you can say the respondent number have been fighting unnecessarily all these cases with that chick. She is the in possession and she is not even a tenant of them. And all the receipts of the municipality taxes that have been paid by them since long have been annexed in my opposition, activity in opposition. Unit. And they have totally failed to establish that I am a tenant under the. And even after, if we for a moment take the agreement which they have produced to be true, even in the terms and conditions of that agreement, it is stated that that place cannot be sublet to anyone without prior permission from the municipality. And they have not adduced any copy of such permission. That's why the secretary just totally tells the order in my favor.
It was the trial. Now they can.
Let's have it on Thursday, 2 o'clock. Let me think about it, how it can be done. Thursday. Well, because there is a big problem this paragraph 22 is the most damaging paragraph of this.
Let it be on Friday.
Right? Well, on Friday.
Oh, let's do it.
The order is. You see, the question which can at best be decided by air is whether you are to be given a hearing or not. The hearing had already happened. Hearing was granted. You see, the reason why the 9-5 order 26-5-97 was interfered with by the appellate court is that order was passed behind your back. So therefore, but the fact remains, whether he's a tenant or not, they have given an independent right. So therefore, this is the matter again on Friday at 2 p.m. for further hearing.
Okay, let's do it.
Think about it.
Maintenance. Petition is filed between the today only. That's what the copy was.
So, it has been submitted that the petitioner had filed a rejoinder today. Had filed an affidavit in reply today. So the said affidavit in reply is not on record. This matter again on 1st of June 2026, along with the affidavit in reply. You have filed? Yeah. Okay, in the meantime, the respondent number 7 shall bring on record its stand by filing the affidavits on or before 25th of May 2026. Liberty given to the petitioner to file reply.
Who's the last one?
No affidavit filed. By the forest. Where is forest? No forest. There's a stay operating, huh?
I'm protected. Out and out illegal one. Perhaps they have also realized.
I Chaudhary, the London Civil Council, assisted by so appearing on behalf of the petitioner. None has appeared on behalf of the Forest Department. The petitioner herein have assailed the order dated 21/2/2023, whereby the petitioner has been put in the negative list of the Kaziranga National Park and Tiger Reserve for a period of 5 years. The learned coordinate bench of this court by an order dated 12/6/2024. State the interim order dated 21/2/2023. The matter had thereupon been listed before this court on 2 other occasions. That is on 11/8/2025. When the Forest Department did not show any interest. Where on 11/8/2025 and 8/12/2025. However, the Forest Department have not shown any interest in the instant proceeding, in as much as, in spite of there being an interim order, the Forest Department have not filed the affidavit in opposition. And today, the Forest Department have also not cared to be represented. Considering the above, this court fixes this matter on 14th of May 2020, 14th of May 2026 at 2 p.m. The writ petition would be taken up for final disposal on the basis of the materials already available on board.
What's the relevance? Affidavit is on transit.
What?
The affidavit, my lord, it's coming.
From where?
It's from Kaziranga. The director was.
Working?
My lord,
It is working
No,
because
no,
the
no.
last,
The
I
authority
fixed,
matter, the-
this matter has come up after 7
understand, madam.
months,
This-
6 months.
We
It
had-
is working from there.
Let's send it on the month of December. And today we spoke about it and then today they have sent it back to us.
It is reached.
And this scan copy which will be the file.
It is reached. The High
It
Court.
transit, my lord. I'm hopeful it will reach tomorrow, my lord. By
Oh,
messenger,
this is yet to reach.
my lord, it's coming by messenger. Oh, my.
I'm fixing it for final disposal on 14th,
My lord.
14th at 2 p.m.
File it today or tomorrow. It's some time to respond to.
No, they have not filed.
They are yet to. Now, in
No,
that case,
they
we'll
have not
renew the
filed.
prayer.
Huh?
If necessary, we'll renew the prayer if they file. Because we don't know.
We'll file.
No, they won't file. It's working. Till now it's not there. So we see that none has appeared for fault.
Oh, yes.
Yes, what is this? What?
Yes, I have filed affidavit today.
The file?
Yes, I have given.
Fishery?
Said,
Fishery department.
but the issue is simple. Issue is,
Fishery or a,
sorry, lordship. Issue is simple, lordship. Without affidavit also, then they, on their admission, lordship, it can be disposed of.
what is that?
On their admission, lordship, I have just gone through it.
The tender submitted the PAN card to the.
I go to this, na?
By being the.
Admission part is page number 30. So I file affidavit, lordship, after going through it, page number 30, lordship, I think, after page number 30, lordship.
Hmm.
Their admission is there, that they have not provided the PAN card in the original, the PAN card of the society in the name of also.
Take your honor would be pleased to accept.
Which is not signed also.
The state of my person. Then, and what was required was,
Required was lordship is his lordship,
what are the documents required?
this is this 2018 notification.
Oh, there, it says that PAN card is required.
This one lordship, I have marked it.
PAN card issued by income tax authority issued in the name of the fishery cooperative society and not individual PAN card. So, hand it over. This means, I don't know. What is that? We are only going to not only see his affidavit. What is there to reply? Your senior? What is his name? Very well. I'll put his name and dismiss it.
Some temporary.
Not an interim order. No interim order. Fishery settlement happened when?
2024, I think. So.
24. Okay, 7 years.
Yes, lordship.
Okay, we have it in 2031. Then your senior can be, then you will become a senior then. Huh? The fishery department has filed an affidavit in opposition on 30, when?
Today.
Today. The said affidavit in opposition, however, is not on record. The learned counsel appearing on behalf of the petitioner submits that he has received the copy and he would obtain instruction as to whether the petitioner would like to file a reply. This matter on 15th of June 2026. In the meantime, an opportunity is granted to the petitioner to file the reply on or before 10th of June 2026. Registry shall bring on record the affidavit in petition filed. What is this?
Apologies, my lord. I'm being led by Didas in this matter. Had a medical crisis because of which we had to rush over there. Ask in comments. From-
So the counsel appearing on behalf of the petitioner seeks for an accommodation in the matter. P.K. Roy, the learned senior counsel, assisted by so appears on behalf of the form number 5 and 6. A. Gayon appears on behalf of response number 1. And official liquidator, Mr. P. Sakian, appears on behalf of the official liquidator of the respondent liquidator, and Mr. D. Jetta appears for the AIS. Taking into account the request made by the legal counsel for every. There's no interim back.
All, no, my lord. Also, my lord, if I may say,
This matter on 20th of July, 2
my lord, if I may request to hold that the pleadings are completed the matter on the last date. We have got sort of directed to allow them to file an affidavit.
So, my
No
lord,
affidavit is going to be filed for the pleadings are complete. That will be recorded.
on 21st of July 2026 for finance disposal. No problem. They have always come back. 21st of July 2000. taking into account that the pleadings are.
That's the last page by the Muslim fine at the bottom. The reason it will be. The bidder Purvanchal will take private limited and not digitally signed and uploaded the bid document in the bid and it is not evaluated and be disqualified in terms of clause 26(1) E of the IPO. But the
Twenty,
26(1)
which is the ITV elected. Pick one.
page 24.
Ten. The scale evaluation, there is employee to determine whether the PA meets the eligibility criteria. For this time.
Yes, that is the ground taken, my lord. If you challenge it, I will put in the point, the technical people.
Madam, we do want to close the liberty to use to exceed. Exceed the same. You don't say this section, you can't do. They have given the reason that you have not signed. Therefore. It's still.
Actually, my senior is on legs in port number two, and the existing council is also on legs.
We have, we don't require agree, but it's otherwise the way we start.
Yes, madam, we have filed our affidavit, madam. We have filed our affidavit, madam. Out of this total bill amount, some amount has been paid. He claimed, the customer claimed 1,452,000, 4,203 rupees, and out of which we have paid. We have stated in our paragraph 8. So you have already paid 44 lakhs. Yes. 1.8 lakhs rupees remain.
Our proposal now being submitted for 37, 38, 19, and 12. So this is the amount. Therefore, outstanding is 1,08,500, 5,009, 1,418 lakh, 5,097 pending. Okay. Oh, it's that. They're going to. And you reply?
Yes, we'll find her.
Did the connected petition?
There was a lot that was disposed of. But that initial petition was filed for rejection of RB dealer. Thereafter, during the pendency of that writ petition, we were allowed.
If the petition are complete, so final. So we have put them in the negative.
Yes, Your Lordship. Our contention is that it is not done as per.
It has been submitted that the pleadings are complete. And and the learning refer
And AJ Sekia.
pages taken the learning council for the petitioner for the submit. That as there has been no, what are the matters requiring urgent disposal? Was taking into account the above, it's this matter of 11th of 2026 that we have to file.
Give your comment.
What's the matter about? It's that? Eight? Maybe interim order is passed.
Yes, sir. Yes, it's already passed, my lord. What has happened, my lord, in this matter is that,
What is the interim order passed?
exactly, my lord. What has happened, my lord, is that I am appearing for respond number 1. Now, my lord, respond number 2 and 3 is, though it is, what happened was on the last occasion when it had come up in the previous court, 2 and 3, no one has represented the main Adarsha Vidyalaya Sanghasha. What has happened, there was, though they are under the elementary, they are part of the elementary, the government, but they are an autonomous, my lord, organization.
Huh?
They're an autonomous organization like SSA. So what has happened is that they don't have a council, my lord. Today I have received instructions, my lord, for this particular case. They want us to file an affidavit today. The organization, the
Yeah, again,
2 and 3, 2 and 3.
you will be filing affidavit.
So I will file now. I will file an affidavit now.
You will be paying for 2 and 3 now.
My lord, that's what my instruction is. That they've asked us for this case only, not as a whole for the organization, for this case only.
When I'm only concerned with this case for my life.
That's what I'm.
My question is,
I will
are
file
you,
my.
are you paying for 2 and 3 or not?
Yes, sir. Now I know.
That is.
Yes.
Simple. Mr. Epukon, the learned council submits that we have been instructed to appear on behalf of the respondent number 2 and 3. And further, the petitioner would be, the state respondents would be filing the affidavit. When
Not 2 weeks time, ma'am.
he therefore seeks for 2 weeks' time to do so. Taking into account the above, when can you file it? I'm not asking how when can you file it, then I'll fix the date because there's a same order. Sir.
10 days I'll pay.
This matter again on 12th of June 2026. Affidavit be filed on or before 1st of June 2026. Liberty given to the petitioner to file reply therein. Interim order passed earlier shall continue till the next week. I was thinking that the 2 and 3 will be represented by Mr. Anil. Because earlier there is also a similar matter wherein Mr. Ponik has taken some interim order and he is not. Like, where you appearing? No, that's another matter. I'm just praying for some accommodation. Yeah, I was supposed to file the affidavit by today. Everything has been ready, but the concerned personal difficulty has not been able to come. It will be taken up any day in the next. There's 91 order also. Page 91, madam. There's an interim order. When we without proper matter thing, that. Ah, yes, this matter, yes. Yeah, we have taken many times adjournment.
No, in this case, not.
It is in the
Another matter.
another.
So here also.
This is the new one.
Yeah, new one.
This is the new one. That is what I passed.
In the other matter, lordship is entire
As well,
tender process.
because we didn't take order past. Last to that, we have taken. Where do you take order? Well, I get a next step, the interim order would be. Mr. S.P. Chaudhary, the council appearing on behalf of the respondent number 2 and 3 submits that a affidavit in opposition would be filed within a week. Taking into account the above, list the matter on 17th of June 2026. In the meantime, the respondent number 2 and 3 shall ensure filing of the affidavit on or before 29th of May 2026. Liberty given to the petitioner to file reply thereagainst. It came on the past earlier.
Getting on behalf of each good factor. Yeah, I have filed the
By the submitted by the
PR Guru.
the council appearing on behalf of the petitioner that an affidavit in reply has been filed by the petitioner. The reports, the registry shall bring on record the same affidavit in reply. This the matter again on 3rd of June 2026.
Wait, please, your lordship. Lordship, I'm appearing on behalf of Mr. H. Talukdar. Lordship,
The irrigation, non-payment of competitive group. Okay, direct pay as the concern.
Lordship,
That is also.
Lordship, if I may, Lordship, Lordship, I was instructed otherwise actually, Your Lordship.
Huh?
I was instructed otherwise actually, Your Lordship. I was instructed to pray for withdrawal, Your Lordship.
Good.
Because petitioner was asked to file additional affidavit with liability statement, but despite effort, the petitioner could not obtain the liability statement, Your Lordship, and therefore I was instructed to pray for withdrawal with the liberty to file afresh, Your Lordship.
It is allowed. Yeah. If you want to get the money, you will get it. If you are not, they will verify and reject it.
But we want to apply. Apply.
In this case, the counter affidavit has not yet been filed. The irrigation department.
The affidavit will be filed within this week, Your Lordship. It has gone for waiting. The affidavit, Lordship.
What do you know? Your DTP doesn't have it.
Not filing everything.
Also, it will be done within this week, Your Lordship.
What do? You are not in a position. They come big meeting. But in the letter, they
See, but this is also for the state, the PTC is the main respondent here, right? Their affidavit with us. Is there's an interim order, my lord? Let us, I'm operating. the thing. What status? My lord, I was operating, but the honorable court has directed that status quo on date, so they have allowed me to operate the sale depot, which was.
Wasn't it terminated?
My lord, the issue herein is that,
What are you telling me?
my lord, I am running a stone crusher unit as well as a sale depot. My stone crusher unit has been renewed permission till 27. The sale depot has, after being renewed permission, within a few days, it has been cancelled without any reason.
What are you telling?
So therefore, I'm challenging the cancellation of the renewal, my lord. The letter, which was earlier renewal was earlier accorded.
Is up to 31 after expiry of which the renewal. What do you?
Page 30, page 30, page 30, the letter page 30. So how can you run? Well, they have given me a letter that you are permitted to run. They issued after that.
That will be a violating. You're violating the order of the score. How are you permitting? See, that is my 23/12/2025. Well, so I'm here cancel the previous permission given to waiver the concerned sale report shall remain closed until further orders. So the person that who challenged it here got a status quo order. Then how are you giving it to him to run?
Also, that's why let me file my affidavit, Lordship. Let me file.
No, I think we should call this problem.
Because Lordship, the impugn order, Lordship, which is 23/12/25, Lordship, that was cancelled in light of the absence of e-auction process, Your Lordship,
Yes,
in the
right.
BDC area, Lordship.
And that is the main issue. They have relied on your lordship's order. Thereby, your lordship had passed an order saying all sand mahals should be formed by e-auction process. My case is simple. I am neither a mahaldar nor a settlement holder. I am not a leaseholder also. I only run a sale depot, meaning thereby I buy the already extracted stones, I crush them and I sell them to the government or to the private parties. I am a commercial operator. My sale depot and my stone crushing unit, these are private entities, these are on private land.
There is no settlement.
There is no settlement. So they are relying on your lordship's order, which has no basis. And that is the only basis that the instruction they have supplied in the file as well. That was the only basis that they have mentioned.
Mr. Bola, I don't think. it's the implement.
My lord may have a hearing, my lord, because I'm ready. I don't need to file a reply.
My question is,
Yes.
I think the implement. There was a director of the status quo. And after the status quo, I don't know what has happened, what is right here. How can we be allowed?
Because
I don't say anything about the.
well, because they issued an explicit letter thereafter. I did not write any letter asking them to allow me to run. I was running till the time the petition was moved. That my oral submission was there on record. But thereafter, well, they issued the letter. Their letter was there.
They issued the order.
Yes, my lord.
They the status quo order passed and how can we allow it?
In compliance with this order, a status quo also they had mentioned. That is what. But I am agreeable if it is heard early as well, because there is, it is only a law point, not even a factual. As per my. There are no allegations, there is nothing. In fact, the BTC council had earlier stated that there was no affidavit required to be previous opinion. There was no attempt to file an affidavit. Only on the last date, they were directed to file that. The instruction which they received, they had submitted on.
Specific time for you to find the applicant by these people.
If we done absolute,
Why did you find it?
that's gone for betting or should be done within this figure. If I pay for an accommodation, or it will be done positively in this. league.
20,000 upon 25 to you and get the department. It's not done. Considering the above and related provided that the survey status for income today evening. How is it possible?
No, my lord, the honorable court had posed the question to me that were we running the stone deep sale depot. I said that nobody had come to stop the sale depot. It was still running.
How to restrict the thing by complaining to the institute. And the freedom to be considering the tenant, provided you just status quo as on today. Once they just status quo, they cannot be, you cannot run.
And the question was posed to me explicitly that whether we were running. I could only give the factual position as instructed that there was nobody coming to stop the sale. Because my lord, another aspect is that my stone crushing unit has still been running. So I'm still crushing the stones. I have to sell these. I cannot hoard the stones or keep it in one place. That was an illogical order which they passed.
The PC, the standing the PC have not filed the affidavit in spite of a specific order passed by this court of 6/4/2020. According. Running is running. For running, they have not ordered it. I think in the month of September. They want to extend. Like, my only problem is not because of that, but they extend it. The couldn't have been a status quo. Should have stayed that order. I was praying for the state. But how can you pass a status quo in respect of closure? Means you can't open it, and they are allowed you to open it.
And even on that day,
They were in fact anything you don't. I not now, unless you produce it before the sport that me. Are you not going to buy anything just to sport?
you know, on the next day, I can also produce that letter which they have issued.
When you were running.
Yeah, yes, man, they have literally gone against their own order.
Yeah, he can't be a. I didn't know for that. You say that you are running.
But again, they are saying it.
Have a copy of that order.
And that I have not taken print out of it next day.
I think very well, alternate position of that order, nothing remains. Any action is further taken, but you can do it.
We are saying in compliance of this order reports. That is another aspect, my lord. They have complied with your lordship's order and allowed you to.
This matter again on.
Lordship. Kindly let it be next figure, Lordship. All right,
No, no, no,
all
we
still
don't
be
trust-
filed within this figure.
We stress on, we don't trust the PPC as well as their counsel. We don't trust. This is the matter again on. 3rd of June 2026. Taking into account that the response PTC, in spite of various opportunities, have not filed any affidavit in opposition this court for the ends of justice. State the order dated 23/12/2025. So far, the same is applicable to the petition. And not. I think that is a better one. But conscience does not permit. That will not violate. The you will also have a problem.
I know.
Okay,
It's-
what is this? Islam, what is it? You are telling us, sir?
But this is the petitioner is the employee of the Apollo Hospital. He was earlier suspended and subsequently terminated. And thereafter, they challenged the termination order to the labor court. The labor court set aside the termination order with the direction to reinstate her to full back work. Then the management had went to the High Court matter. The other single judge has dismissed the petition. Then for writ appeal. Writ appeal also dismissed her. But thereafter, she was reinstated, but the full back wages was not given. Then she filed an application before the labor court under section 33C2. And this petition has been dismissed, my lord, by order date 36/2002.
Before they come,
The record has not come.
who is appearing for this?
My lord, not appeared earlier the,
Service is complete.
yes, service complete. The Lozima court was there.
The ID card is.
Record.
Record has come, na?
Yes. Record I have to.
One day. The effect service by way of trustee. What has also not been.
Yes, yes. Record not confirmed. The initially the motion stage was
Petitioner
also.
hearing. The petitioner hearing has sailed down. What they take the 2025. As per the learning legal form in reference case number 4 2020. Whereby the application filed by the petitioner under section 33 C.
Yes.
Capital C.
Yes, my lord, for the execution of the labor court.
You file the application for quantification.
Yes.
It's a quantification. Capital C, bracket 2 was rejected. In the opinion of this court, that taking into account the allegations on which the instant petition is premised, the reports of case number 4 of 2023 would be required. The registration therefore directed to call for reports of case number 4 of 2023 from the learned labor court of Gauhati. This one also has taken note of that the respondent number 2 has not been the appearance. And this one have been serviced on the basis of the order passed by the learned law by the laws of the court. However, for the interest of justice, the opinion of the court that in case of justice, this court directs the counsel for the petitioner to take steps upon the respondent of the courts by way of the state, rooted through the registry of this court and find an affidavit of service on the court the next day. Mr. Matter on 22nd of July 2026. The registry shall ensure that the reports are available. The petitioner shall effect service upon the respondent accused by way of the state, rooted through the registry of this court, file an affidavit of service on or before the next day. The petitioner should ensure that the service is effective upon the respondent of the court on or before 19th of June 2000.
Much.
AFDC,
Chief, need some time, Lordship. I need some time to go through all the records also.
Huh?
My department has stopped time, Lordship. Because, Lordship, in some of the cases, I told these things, yes, in the, they have said that they have completed 80% of the work. This is not supported, and we could consider only the repetition, there is no work completion certificate is also. Not, so not there, Lordship. You have to verify it, Lordship. AFDC, AFDC.
APC seeks for one final opportunity to apply this form to whether the petitioner is entitled to the amount as claimed. Which this matter again on 17th of August 2026. The APC shall ensure that the instructions are placed before the school by way of an affidavit on or before 12th of August 2026.
I have it.
Mr. Hawkins,
And affidavit is ready, my lord, we will be filing it by Thursday. After my lord, issuance of the letter of acceptance, it has been cancelled, showing technical ground. We will file our affidavit. LOA issue, thereafter it has been cancelled, before entering into the contract.
LOA was issued, thereafter my lord, bank guarantee was, performance security was, my lord, submitted my lord by a bank guarantee.
we are getting hold of other contractors also.
My lord, here, interestingly, my lord, the ground, my lord, that was already my lord, said by one of the court, my lord, that they wanted to advise the DPR, my lord. In fact, my lord, the earlier occasion, my lord, we were awarding the letter of acceptance, my lord.
We have a good case. It's the ego go it a little.
Why within 7 days? We didn't just move by
Within 7 days. 17 June. Call for June.
and either way, my lord,
You don't file the agreement, what will I do? They can pass your year. Interim order was passed on 25 June. Then you, we are months thereafter. Who want only the court should sit out here and think that whenever the PWD is urgent, then otherwise. Okay. When, what is this matter? Non-payment,
On disbursement of the letter.
huh?
Petition, Your Lordship.
Huh? Maintain, why, delayed?
One party, then second party liability statement is not issued by the chief engineer, Your Lordship.
What liability?
So they had annexed one, completion certificate. By the executive. But. Page number 17. This one is also there.
What delayed?
Work order is issued on October 2020, Your Lordship.
Hindi allow. Don't, they were looking into, where I was missing this something out there. Date of completion is 24/1/2023, madam.
That's true, Your Lordship, but you have to file it.
If I do it, if I accept that contention later on, would be, your other colleague will be targeting you again.
This type of submissions are. It's okay. I'm not on this liability statement even or not. This is the water resource department. The question is whether you are to pay or they are to pay. Whether you are there. Accountant, no, you also appear for CGC, no? Where,
Not the third of your can package your.
huh?
Can package. What are you?
You do one thing, verify and pay. 6 months. Verify and pay, because this is an amount of it. I thought, you know, who is to pay, yeah?
What are you?
Water resource is there. Suppose. Yeah, what do they?
Product department order has been issued without consideration of the rest contract matter. Without consideration of the rest contract.
In order,
And they,
without cancellation of the rate contract.
page 153. That's page 1.
Think we can allow this petition in the same terms.
I know it is product department.
Huh?
It's product, only 2 products that we department.
Product to the,
Yes,
not from the law.
product, 2 product matter, they are same to supply matter. We don't make it. But that is, that contract is. Right? That's also that contract.
Why?
That is the, 154 year old. So that is what. Yeah. That's the. Based on. It's what. Starts with this one.
What do you think?
Cancel the contact partner.
Why is it required to cancel the rate contract? Rate contract is different. I understand properly. Initially, there will be empanelment contract. Then there will be another process of an NI amongst them to find out the rate. Now, once the rate contract is arrived at a particular amount, just for example, 100 rupees. 100 rupees is being given by the highest bidder or the lowest bidder. The lowest bidder would be given certain quantity, fixed quantity it is there. He has a right. 2 and 3 or 4 or 5, whatever it may be, they can be permitted to go to a supply at that lowest bidder's rate. Now, if you are 2 or 3 or others are supplying, the moment we cancel the rate contract, what will happen to the 2 and 3? There will be nothing.
Respect of my lord, only respect of that one. Respect of that one.
So therefore, there must be other forms. So there might have paralleling rate contract.
That different contracts are made.
We are not concerned. We are concerned with agreeing with this. They will be
And more the rate contract. However, submitted, we have submitted that we should not supply, we could strike in the six. They said that no, we have submitted quantity, we have not. What? That is that page 1. Page
That page 59, we have said,
You have supplied wages. 59%. 52%.
no, there, you have also find, my lord, that goods are ready, because supply, because they are this time. And then, my lord, they are replying at page 160. There's no, goods are sufficient stock is there, so we are not. We are not.
Now, once you contract the plant, and then after that, if you are now depart from two, then another two, if it happens, then you go for from bigger. But after three, then one more is left. Then you go for five. Then
The product. But in fact, the operators are lightly done, so like people.
without going ahead with that, then it's only after three, then they can. And the rate control, because there is a reason why, because they will have to go for another 3 years. See, kindly see, Mr. Traveler, kindly see, people have closed 9 even now. Exactly. After the empanel process, page 47, is completed, and the empanel manufacturer are asked to submit their prices against a specific fulfillment. Then empanel manufacturers shall quote the rate. So and so, so and so, so and so, so and so. For each of the items it intends to be from. These with conditional variable rate shall not be accepted. So handling area will not be paid for. Delivery shall be made at the location as stipulated in the purchase order. So the rates as quoted and accepted and contracted will be firm or binding on the bidder. And any increase in the price will not be entertained till the completion of the supply, and any increase in the price will no bidder shall be allowed at any time on anywhere whatsoever it may be to claim revision or modification or representation to so and so. The rate shall be quoted in the unit rate and only for the composition as well. Therefore, then another thing, another clause is there.
Yes, but I not at page 43. Page 43, 43 clause E.
Purchase order will be issued in 60, 25, 15 to L1 and 2 area, subject to L2 and 3 agreement. If it does not match the L1, then the next lowest bidder will be offered as L1. However, if the value of purchase is less than 5 lakh, then the entire contract will be awarded to in case of lesser than 2. Now, therefore, if rate will be big, they will be rate is fixed. So if we consult the rate contract, what will happen? The others will also not supply. Will big more chaos. No, this I will not take up next week. I will have it on 26th or 25th. I'm not there. You don't want to find a reply? It's the DN file of the council. It's the petitioner who would like to find a reply to the activity. This matter again on 25th of May 2026. In the meantime, the petitioner will be limited. Yes, I told you. You think that I don't sell right? You wait, Mr. Dinath. One matter is there. Not this matter, another matter. The petitioner herein has approached this court, challenging the action on the part of the respondent authority in holding the petitioner's bid to be technically responsive
technically non-responsive. By the communication dated 16/2026. And that too without assigning any reason. This court had inquired with Mr. P. Gogo, the learned regional advocate general, as well as the standing counsel of the PWD. As to the reason as to why the petitioner bid have been held to be technically non-responsive. The learned counsel submitted, the standing counsel for the PWD submitted that the petitioner's technical bid has been held to be non-responsive in view of the bid having not been submitted in terms with clause 26.1 bracket B of the instruction to the bidders of the tender documents. A perusal of the clause 26.1 B bracket B of the instruction to bidders show that that the that an evaluation would be carried out. Detailed evaluation of the technical bid should be carried out. On various bases, which include as to whether the technical bid has been properly signed. A copy of the technical evaluation sheet have been provided before the spot, which is kept on record and marked with the letter X. A copy of the state technical bid evaluation sheet have also been provided to Mr. T.J. Mohanto, the learned senior counsel, representing the petitioner. Mr. T.J. Mohanto, the learned senior counsel, submitted that the petitioner would be well advised to withdraw the instant writ petition and again refile by challenging the state technical bid evaluation carried out if so advised. He, however, submits that the withdrawal of the petition from the present proceeding should not affect the cause of action for which the petitioner filed the present petition. Taking into account the above, the instant writ petition therefore stands closed on withdrawal. The withdrawal of the instant writ petition shall not preclude and or prejudice the petitioner to again approach this court if so advised. You got everything in the morning? Yes, Mr. Nath, one matter was there. Right. Yes, I would not put the personal appearance, I would not, I'll remove it. But you get that instruction, the number, and give it to Mr. Made. We then have it on the matter day after. I think 10 to we have it on there. Mr. Mr. Tina, the learned counsel appearing on behalf of the respondent number one, huh? Respondent number one, huh? Respondent number 3. Admits that he would place necessary instructions on Wednesday. List the matter again on Wednesday. You keep this matter. Can you find a proper 1 page? Let's have it on the writing. Admits that the amount to which the petitioner is entitled to have already been disbursed to the petitioner. So, in that regard, he submits that he would put the said straight by way of an affidavit. List the matter on 15/5/2002.